when our application.
Urgent today?
I've got a similar prayer,
Today?
my lord.
But tomorrow, my lord, motion है. Yes.
Site visit?
No, my lord, contestant work.
Lordship, I wanted to pray for a listing of a petition for motion today or tomorrow, whenever it is convenient.
I don't have motions much, I suppose.
Tomorrow then,
You have today also, no problem.
deeply open.
I mentioning item number 28. My lord, 28, my lord, on the last election, my lord, if my lord was posted, my lord wanted me to make a mention for upgrading, my lord. It is a item number 28, my lord, and 10 for an upgradation, my lord.
Why?
My lord, on the last occasion, my lord was pleased to, my lord, give a direction like to update the matter whenever the matter is posted before your worship, my lord. My lord, there is an order of the law, my lord.
The contempt case. Oh, it's in the motion.
Order follow. I wanted to seek instruction from the PhD department. So,
No, it's in the motion actually. I have not issued notice in this matter. Oh, notice has been issued. Oh. Okay. We'll see.
I'm applying.
May I please, Your Lordship? Also, I beg to mention item number 18, my lord, 18. Did this contribution become infractions, my lord?
Complied.
Lordship.
Mr.
M. Mohanto, my lord.
M. Mohanto, the learned counsel appearing on behalf of the petitioner submits that the order dated
Order dated 4/6/2019, my lord.
passed in
Pass in WPC common, pass in 4822/2018 and WPC 6022/2018.
no, there is only one. How many contempts you have filed? Only one.
Only one, my lord. It was passed in two petition, my lord.
In your petition, which petition?
My petition is 4822, my lord, 2018.
Have been duly complied with. He therefore submits that the order, he submits therefore the petitioner would not further press the instant contempt application. Accordingly, the contempt proceeding stands dropped.
Fine, my lord.
Thank you, Your Lordship. I'm paying for listing for motion tomorrow. Wait, please. Good luck. I beg to mention a fifth resolution for listing tomorrow.
Okay, please, Your Lordship. Lordship, in item number 37, the petitioner has filed the affidavit in reply today.
What has he filed?
Affidavit in reply.
Okay, you want to bring it?
To bring it on the top. Much of that.
Middle list or motion item 32.
Wait, please, Your Lordship. Your Lordship, what's an order? On the civil file page 7, my lord. This order dated, my lord, this is 12. 11, my lord. But thereafter we submitted the, my lord, order. They have not taken any action, my lord.
Huh?
They have not taken any process for the finalization of your lordship order, my lord. The lordship of the order on 12/11/2025, almost more than 1 month, my lord. We have approached repeatedly before the authority, my lord. But nothing has been.
Wait, let us get hold of a standing counsel of the PNRD.
Existing, Mr. Madre. If you're watching, see whether the. Doctor, chief. My lord, your losses may see again, my lord, clause, my lord, page 47, my lord.
Where is the impugned communication?
This is a perverse, my lord, where, my lord, this because the proper notice was issued by the general manager. And that is in respect of, my lord, various items, my lord, we have already supplied, my lord, 93% we have supplied. So this clause itself is not applicable. I have given the chart, full chart, my lord.
Where is the impugned communication?
Impure communication is, my lord, 131.
One,
No, that is 136. 136. They have 17, my lord, items they have mentioned, my lord, but here, my lord, we have already supplied, my lord. I can show from the, they have not applied by my purpose.
why perverse?
Purpose, my lord, just one item I show, my lord. Purchase order is at page, my lord, 257. 257. 257, you have to also see. It is one of the items for which matter I have been declared.
Oh, have you seen my recent judgment on these points?
Yes.
Have you taken up that plea?
Bid contract.
That
Only contract that
that
has to be
contract-
cancelled first. Before proceeding.
Nothing has been done, and moreover, before fire department, the item department should be there, my lord. Which is, nothing has been done, and proper notice has been issued, not from.
Yes, we are fixing another matter. When is that?
That is fixed on 9th, I think, madam.
We have it here, no stay. We'll have it up.
My lord, the goods are lying, my lord, here, my lord.
No heavens will fall.
My lord,
No heavens will fall. You see, they have made a mistake that equally you have also not supplied.
no, we have, well, if you also see whether documents are there.
No,
that
documents are
93%
there,
of-
but these are disputed. I have to give them one
Their
opportunity.
portal, my
to-
lord, sold. Their portal sold, my lord.
The portal may show many things, but the
But-
fact remains out there that, you see, let them, I'll give them the opportunity to look into their judgment and take a call in the meantime.
Only thing, my lord, the goods are lying there, my lord, there.
No, I'll have it on 9th. I'm not going to interfere because you see, my principle is when you are blacklisted, you have to give him an opportunity.
My lord,
And after getting an opportunity, if this court will pass an order.
well, that's correct.
But the fact remains out there that without giving them an opportunity to pass a stay order means you stay the entire thing, means you give a final order, which I'm not going
My lord,
to.
only thing, my lord, they may be, well, if they allow, my lord,
The same principle tomorrow, today, if I'm allowing
Say,
you,
my lord, I'm
would
not-
this court not be violating Article 14?
my lord.
Why you and Mr. B.D. Das? I didn't allow Mr. B.D. Das, but he also said that kindly grant me a stay. So next time you will also remember that we should therefore comply properly. And in the meantime, Mr. Bora, you advise your clients to
Yes,
take
madam.
that decision properly. Because
Yes.
you see, without a rate contract, you see, have you gone through the judgment?
Yes, my lord.
There are, it's a very interesting thing, although it was not submitted then. I was just thinking how, when they were making the submission, how there was a rate contract. If the rate contract goes, what happens to the other people? Because L2 and L3 is being given. Then you see that clause 24, section rule 24, I1, Roman 6, which gives the concept of a parallel contract. So if you have a parallel contract, you can further go ahead with it. Otherwise, you have to again go in terms of 4B, Roman 3,
Yes, my lord.
Roman 2. So therefore, you need to, that is the, I think, the reason why, if there is a single rate contract, no parallel contracts, you will have to again issue another tender.
Yes.
That is the why you will go for a product department. And if there are more than 3 product departments, then so you need to therefore ask your client also to first go for a product
Product.
department. And then the next course of action,
Yes, my lord.
without cancellation of the parallel rate contracts, qua the petitioner, how can you go there?
Yes, my lord.
July, from July to September, the blacklisting is in just up to March, my lord. Up to July to September orders, these are lying, my lord, and goods are lying here, my lord. For this, they have blocked up in court, my lord. Just my lord. Otherwise, we couldn't.
No, if these are work orders, I passed another order in that case, very case itself. You are right, if those are work orders issued prior to that, taking into account the public interest, you can very well accept that.
Yes, my lord.
If you accept or not accept, that is a different thing.
That is what, my lord.
Bad, you can do that.
They've taken
You
it.
have that order, anybody has that order of Mr. Nestor's first order? I think same order should be passed here.
Yep.
Giving them you to file your reply and all. Hey, Nestor Edna judgment to Junto Disu. You have that copy of that order? The second one?
Stop. Second one I have.
Second one, give the number. Just get the number. So if it is still in the soft copy, it has not materialized in black and white here. Mr. Bora, have they taken that plea? No.
No, my lord.
Ah. You file your additional affidavit also, take up that plea, which you have not done.
Yes, that plea has not been taken here, my
Ah.
lord.
Yes, this pre-existing.
The issue notice making it returnable on 9/1/2016. Mr. DP Bora accepts notice on behalf of the respondent numbers 1, 2, and 3, isn't it? 1, 2, 3, and 4.
1, 2, 3, 4.
At 28, we have taken this plea, my lord.
The petitioner herein have assailed the communication dated 15/11/2025, whereby the petitioner company, petitioner firm has been debarred by a firm debarment notice for a period of 3 years from the date of issuance of the said letter as per referred tender clause number subclause H point Roman 2 and Roman 3 and clause M for default of in supply of 13 numbers of essential drugs against 17 numbers of purchase orders, details of which have been given in annexure A to the said communication, impugned communication. The learned senior counsel appearing on behalf of the petitioner submitted that a perusal of clause 5H Roman 1 would show that if the supply in question is more than 90 or more, the question of product debarment cannot take place. Pustak. He further submitted that without there being a product debarment, the question of going to firm debarment in terms with clause 5H Roman 2 also does not arise. Pustak. In that regard, the learned senior counsel drew the attention of this court to the various purchase orders and the supplies which have been made as would be available from the MRC material register certificate, material receipt certificate of the supplies so made. Full stop. He therefore submitted that the impugned communication has been issued without proper application of mind. And in any view of the matter, the said communications cannot be sustained in law as well as per the terms and conditions of the contract. Per contra, the learned counsel appearing on behalf, Mr. DP Bora, the learned counsel appearing on behalf of the respondent submitted that the petitioner in the instant case were issued various purchase orders in respect to 17 numbers of drugs, essential drugs. Referring to Annexure A to the impugned communication, the learned counsel submitted that the petitioner, that the period within which the supply is required to be made is 75 days. But there are certain instances where the petitioner have not supplied for more than 2 years, as would be available. Under such circumstances, without first giving an opportunity to the respondents to ascertain as regards the to counter the statements as well as the enclosures to the writ petition, this court may not pass any interim directions. Mr. D.P. Bora, the learned counsel, also submitted that passing any interim directions, thereby staying the impugned communication, would amount to granting the final relief. And as such, that too without an opportunity to the respondents. This court had given an anxious consideration as to whether any interim relief is called for in the present facts and circumstances. It is the opinion of this court that, taking into account the various allegations and the submission, taking into account that the various allegations in the instant writ petition and the submissions so made by the petitioner, counsel for the respondent, the respondent authorities, it is the opinion of this court that, taking into account the various submissions made by the learned counsels appearing on behalf of the parties, an opportunity has to be given to the respondents to bring on record their stand before passing any interim directions. In fact, it is the opinion of this court that the instant matter is required to be disposed of as early as possible, taking into account that the matter pertains to supply of essential drugs. Accordingly, this court directs the respondents to bring on record their stand by filing their affidavits on or before 6/1/2026.
On or before 7/1, in the other case, 7/1 has.
7/1/2026. In the meantime, this court also, Mr. G.N. Sahewala, the learned senior counsel, further submits that the petitioner also, in view of a recent judgment delivered by this court on, what is the date? 11/12/2025. In WPC number 6735/2025, would also like to file additional pleadings. Such additional pleadings be filed on or before 5/1/2026 by providing advance copy to Mr. D.P. Bora on or before 29/12/2025. List the matter again, list accordingly. On the next date, this court may consider passing of interim directions if the writ petition cannot be taken up for disposal. This court also, before parting, this court also finds it pertinent to observe that in similar matters, certain orders have been passed by this court. More particularly, the judgment and order dated 11/12/2025 in WPC number 6735/2025, wherein the learned counsel appearing on behalf of the respondents herein also was also present. Under such circumstances, the liberty is given to the respondents to take a call in respect to the impugned notice from debarment notice pending the next date.
Obliged, madam.
Where is the PHE? What is this, PHE or what?
PH.
PNRD?
PNRD.
No, you have got a PHE council. Where's PNRD?
There's 13, item number 13 is there.
We'll see when he comes. Okay, the moment we see him, we'll take it. Yes, what is this?
Or the petitioner was newly appointed secretary, you know. Then the first occasion, my lord, he has defaulted from lifting the PDS article from the FCI or from the government. For that, my lord, the society has been, my lord, the PDS article is tagged with another society. Because the 10 months have already passed, my lord, the society is without this. Your lordship will find.
Where?
Yeah.
Impugn order?
Yes, my lord. At page 30.
Then,
Third paragraph, in view of the above, it's clear the approach secretary has violated the above clause immediately even after receiving the lifting order from the end.
then what happened?
Then, my lord, Sockos was issued.
Hmm.
That is next annexure is Sockos.
Hmm.
Then he has said that I was ill, I was confined to a room I could not have position. Even
Then,
though there is a time also, my.
then,
My lord, I have submitted the Sockos reply.
then,
Then, my lord, still pending, my lord, it's like that, my lord. So I have come. Then,
take a decision.
Yes, my lord.
Nothing else. Take a decision. You have issued a show cause. So he has given a reply. Take a decision. We dispose it of.
Yes, madam. May I take instruction on, because madam, already they may have.
I'm not asking you passing any other direction.
Hmm.
You have issued a show cause. He has submitted a
Yes.
reply.
Yes,
Dispose of that.
yes, yes.
Take a decision. You can't keep him hanging. Say that
Hmm.
Mr. B.C. Sinha's client is not good. He's sleeping. Well, heard Mr. B. Sinha, the learned counsel appearing on behalf of the petitioner. Mr. M. Setia appears on behalf of the all the respondents.
No, 1 to 4, madam.
Respondent numbers 1 to 5.
1 to 4, madam.
1 to 4. Ms. So-and-so appears on behalf of respondent number 5 and 7. And 6?
6 is the private
this is the
respondent.
one whom, my lord,
With whom my lord
Okay.
the
take
petitioner
much.
said.
5 and 7. Who's taking into account the order which this court proposes to pass, this court dispenses with the service of notice upon the respondent number 6. The case of the petitioner herein is that the petitioner is a secretary of a society in the name and style of
Like
Which one?
Mr. Purna.
Rajeshwarpur Cooperative Society Limited. Full stop. The said Rajeshwarpur Cooperative Society Limited was appointed for lifting of the PDS commodity. Full stop. On the first date on which the said society was required to lift the commodity from the godowns of the Food Corporation
Yeah,
of
yeah, food
India.
products.
The said society failed to lift. Resultantly, by an order dated 9/1/2025, the Assistant Director, Food, Public Distribution and CA, Hailakande, had no, where is that?
26 one.
Oh, no, not that, it was 26 one, 911, had temporarily tagged the society, namely MS Rajaswarpur GPSS Limited, to the nearest GPSS, that is the respondent number 6. Full stop. Pursuant thereto, a show cause notice was issued to the petitioner, who is the secretary of the Rajaswarpur GPSS Limited, on 27/1/2025. The petitioner thereupon submitted a reply on 1/2/2025. Till date, no decision has been taken in respect to the said proceedings. And being aggrieved, the petitioner has approached this court. This court have duly heard the learned counsels appearing on behalf of the parties. And it is the opinion of this court that when a so-called proceedings have been initiated, it is also the obligatory and bounden duty of the concerned respondent authorities to bring to a close the said so-called proceedings by a decision. More particularly, when the petitioner had already submitted a reply as far back as on 1/2/2025. Considering the above, this court therefore disposes of the instant writ petition, thereby directing the respondent number 3,
Yeah, 3 months.
3, to dispose of the said proceeding, the respondent numbers 1 to 4, and more particularly the respondent number 3, to dispose of the said so-called proceedings in accordance with law. The same be done within a period of 60 days from the date of today's order.
All right.
Mr. M. Setia, the learned counsel who represents the respondent numbers 1 to 4, shall duly intimate the respondent number 3 of the present order.
But. Wait, with your lordship, some technical contract is with your lordship. The work order is of 2012, your lordship.
Jal Shakti?
I have missed the case, my lord. So sorry to say, my lord, because my name or union is not shown in the cause list, my lord. Kindly, my lord, immediately after vacation on 6th, my lord.
Have you filed your reply?
On that day, I'll file, my lord. In the meantime, I'll file my reply also, my lord.
Is it required to show your name for filing the reply?
No, my lord. For my lord, I missed the case, my lord. For not of that, my lord. I missed the case today, my lord.
Ms. A. Gayan, the learned CGC, submits that her name was not shown in the cause list, and as such, it totally escaped the attention that the matter was fixed today. She further submits that the affidavit has also not been filed on behalf of the Ministry of Jal Shakti. And accordingly, list this matter on 16 to 2026. In the meantime,
Six.
the respondent number 5 and 6 respondent are directed, are given the liberty to file their affidavits on or before 9th of February 2026. Full stop. It is observed that if no affidavit is being filed, comma, this court shall presume that the respondents, the said respondents do not want to contest the contentions of the petitioner, and the writ petition would be disposed of on the basis of the materials otherwise available under the courts.
Master bless.
Who went to
Please say.
same?
What?
Item number two and item.
On the name of Miss Gayan A. Gayan, the learned CGC be shown in the cause list. You now know the date also.
I'm not for the name, my lord. CGC is not only.
No, no,
stated, that's
no,
what-
no. Then we can catch hold of you directly. Where is Miss A. Gayan next?
Then I'm not from my name, but CGC or union is not so in the cause list.
You appeared last time,
Yes, my lord. I
so therefore your name.
yes, ma'am.
328. One so.
Yeah.
Same order, all three, file affidavits. Madam, we need to bring a close to all these problems which is being faced. You are having centrally sponsored scheme, giving it to the Water Resource Department. Water Resource Department is taking a plea
Yes.
that yes, he is entitled to this amount, but however, we have not got the money from the.
We have
Finish.
already released some some portion of the amount.
Therefore, the question is, something has to be culled out. Unnecessarily matters
ma'am.
being pending because of this cannot happen.
Yes, ma'am.
In fact, that earlier order which was passed by the learned coordinate bench, I think that 27/9/2022.
Yes, my lord. Yes, my lord.
Yes, that in the batch of petition, there was a direction upon the Water Resource Department to place it before the Ministry of Jal Shakti. Ministry of Jal Shakti was directed to release within
Yes, sir.
60 days and thereupon to make the payment.
Yes, my lord.
Now, the problem arises out here is that the Ministry of Jal Shakti is not taking steps, or
No.
you are to therefore make it very clear to that, they'll look here, we have already released this and they
Yes,
have
ma'am.
not paid, done it. Then we can then
Yes, ma'am.
catch hold of the Water Resource
Yes,
Department.
After that,
Because of you, the petitioners are suffering and the Water Resource Department is happy.
well, after that order, we have already released some portion of the amount, my lord. Almost, my lord. I'll file in affidavit, my lord. Details.
Shalom.
Yeah, but in this case, I seek some accommodation to file a reply.
What?
In this case, I seek some accommodation to file a reply against the affidavit in opposition, which has been filed by the respondents.
Okay. Any stay?
No stay, Lord. But Lordship, I think.
It is Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ah, there is an interim order.
Lordship, there is no interim order. Lordship, I
Huh?
think it is a typographical error in the order.
Oh, it is Belek Tumara order Kumal Niki. The year 2015. I know. Like that. Yeah, I'm a Pradeep. See, this is some other order must have gone in. Mr. P.K. Roy, the learned counsel, senior counsel appearing on behalf of the FCI, na?
Lordship, 228.
FCI
Yeah, Lordship.
submits that there was an inadvertent error in the order dated 16/7/2025, wherein it is recorded that there is an interim order passed and the said interim order passed earlier shall continue till the disposal of the writ petition. Full stop. Taking into account the said submission, this court have duly perused the records and it is seen that there was no interim order. Full stop. The same being an apparent mistake of this court, comma, this court observes that as there was no interim order passed earlier, the question of the paragraph number 4 of the order dated 16/7/2025 shall stand deleted. Full stop. Mr. So-and-so, who represents the respondent, a petitioner submits that the petitioner would like to file a reply. It is seen that the respondents have already filed their affidavit in opposition as far back as on 28/8/2025. First of all, taking into account the above, list this matter only after the taking into account the above, it therefore appears that the petitioner has no urgency. Accordingly, list this matter only after the affidavit in reply is filed. প্রদীপক কৌশল অকণ চাবলে মনত ৰাখিব।
May it please, your lordship. Look, in
Yes.
this matter, the subcommittee has already, my lord, completed the work and it is placed before the main committee, my lord. And main committee was supposed to sit on 16th,
It has now gone on 4-1.
5-1, 5-1, my lord. I have got,
The problem was there was
On
a
that
full
day.
court meeting.
yes, my lord.
Okay.
So.
List this matter on list these matters again on 29/1/2026.
Fine.
For an update as regards the draft rules.
Highly obvious.
Interest has not been paid. That interest amount which was there, they paid the principal amount, the interest is not paid.
They are not appearing.
People are there, not seen.
If they are not appearing, no problem. Take action.
Apologies, sir. Your lordship, we have made a portion of the interest payment today. I was just receiving instructions from my client. He will be sending me the payment advice soon. Some more time may be given. I'm not sure what the total amount which was paid is.
You said 2,31,000.
Your lordship, I don't have the payment advice with me.
It's okay, no problem. But you said that 2,31,000 or 32,000.
Your lord,
Isn't
I have just.
So my instruction will be around somewhere around 4 lakh. 9% interest, that too from.
She said something like 2 lakh something.
Your lordship, an amount of 2 lakhs has been paid. The additional amount, your lordship, may give us some more time, we'll make the payment, your lordship.
When?
Your lordship, a couple of weeks more time, your lordship.
Hello? Couple of weeks means we have it on the date of reopening. Couple of weeks is over.
Yes.
When?
Your lordship may have it on the 7th of January, if permissible, your lordship.
I give you more time. Let us have it on 21.
Yes, your lordship.
In the meantime, you ensure that the payment is made.
Yes, your lordship.
Else we are going to take it up. Ms. So-and-so appears on behalf of the respondent number 5 and submits that the interest amount would, as per her instructions, the interest amount would be paid to the petitioner on or before the next date. Taking into account the above, list this matter on 21/1/2026 for an update.
Obliged, your lordship.
My lord, I'm praying for some more time, my lord, to file.
What?
Lordship had directed to file an affidavit through the chief engineer. My lord. I have,
Paragraph 7, it is mentioned that the petitioner is only entitled to demand in the amount of rupees is denied. However, the same has certified the liability for another. Yes, where's the affidavit?
I'm seeking some more time, my lord, for that affidavit. I
I
have
know,
asked,
we see the person concerned tomorrow.
it's just some.
Tomorrow. Tomorrow we will see the chief engineer PhD because he was asked to clarify that very aspect. This is the reason why I'm doing it, not for any other reason why I've asked the chief engineer. Because your executive engineer keeps on giving the liability statement, he then files an affidavit contrary to that.
That,
So therefore,
Yes,
let
sir.
us again have the secretary. Last time we had the special secretary again and point him out. Chief
only,
engineer tomorrow.
only one more opportunity.
Tomorrow.
One more.
Opportunity is tomorrow. One more you are asking, I'm giving it to you tomorrow. Mr. Bottakor, are you not serious about your cases? Or you're not, I'm not saying about you, about the PhD department. The executive engineer has no problem in issuing a liability statement saying that he's entitled to 57 lakhs. When I issue a notice out here, he comes up and files an affidavit. Then no, 27, no, 26 he's entitled to. How is it possible that? Have you taken any action against that executive engineer?
We have, my lord, advised the chief engineer to do whatever is necessary to correct the discrepancy, man.
No, discrepancy is not that. Why these executive engineers are giving this type of liability statements? That is the reason why I got the special secretary on one occasion and asked him, kindly rectify these in your department.
Hmm.
And this is a glaring example of what is happening.
State of affairs is, my lord.
Huh?
The state of affairs is
Very poor.
sorry, for
Mr. Ibothakur, the learned standing counsel of the PHE department submits that pursuant to the order passed by this court on 1/12/2025, the chief engineer PHE department, which one?
water.
Water, PHE, water department, have made certain inquiries as to how there can be a discrepancy vis-a-vis the liability statement issued by the executive engineer, Hosai PHE division, and the affidavit which has been filed by the same executive engineer before this court. He therefore submits that upon making such inquiries, the affidavit would be filed. Accordingly, lists this matter on 5th,
My lord, fifth, I'll file this.
on 7th. 7th, the affidavit of the chief engineer be filed on or before 5/1/2026.
Published.
Filed two additional affidavits yesterday, my lord.
What?
Two additional affidavits.
What is that?
I'll just give you 5 minutes time. All of this entire case which was brought on record, the case was only on one point. That's made up without there being a prayer, my lord, for condemnation and delay. Delay would not have been condemned, and Mr. Lawson recollects. On that day, we discussed about this case of Kerala and others versus Krishnan, where my lord, this case of Kerala versus Krishnan and Indian others, where the word Kumbhakarna and Ridvan Winkle was on a point by the Supreme Court. I have a copy of the judgment.
No, that is a different aspect.
No, thereafter, my lord. There is. Now I have brought on record that petition which had been filed before the, my lord, this officer, my lord, the special officer, empowered officer. That petition which was filed against which we did not file our written statement, nowhere contains even one line by which, my lord, delay was sought to be condoned. Because then, my lord, on that other day, Lordship had pointed out the case of Sheshnag, my lord. Which, my lord, in the case of Sheshnag, my lord, it was stated that a recurrent petition is not required. If the grounds for exemption and condonation of delay is made out in the petition itself, my lord.
No.
Yes.
Sheshnath doesn't say so. No. Kindly see Sheshnath, paragraph 61.
So anyway, my lord, thereafter, my lord, there is.
That case.
No, kindly give me 5 minutes, my lord, to make
5 minutes is over.
make my submissions, my lord. That petition which your lordship sees, my lord, in that petition, there was not even a line by which, my lord, the delay of 4 years was. sought to
See,
be
the
condoned.
reason have been given by that authority concerned in that order. Why there was a delay?
Even that is not there, my lord. It only said the delay was condoned.
No. No. I remember that.
This is it. Page 61, my lord. 61, third para.
Please, page 61.
Yes, sir.
This is given.
During the condolence period, the applicant has provided a satisfactory explanation for the delay in filing the application.
The matter was heard where both parties presented their arguments. Learned applicant contended the delay in filing so and so year, which was kept here without any statutory, was the fault of the imam. And as they have given only the capped amount, although they were entitled to, the claimant stated the matter came to light when the so and so is here. The regarding condoning the delay, the applicant had provided a statutory explanation for so and so. Why should we interfere with this?
Now, my lord, kindly,
And that issue, Mr. Chaudhary, that issue, I have foreclosed it there. On the date on which I issued that notice.
that was not foreclosed.
No, no, I have
Kindly
closed it.
go to the-
I'll make it now more clear. No, no.
Then I will go down to the lordship, whatever, personal, kindly may have a look, my lord.
Addition, the petitioner so and so per contra. This court has given anxious on whether an interim order. It is relevant to note that the respondent number 2 has given due reasons why the respondent was permitted to file the application beyond the. This court further takes note of that the petitioner did not object to the condoning the delay before, and as such, this court is of the opinion that the petitioner do not have any case challenging the proceedings before the respondent number on this aspect. This is the finding.
The very petition has been laid only on that consideration.
So then we say that in view of that, we close it. No appeal thereagainst has been filed.
We just take a note of this judgment, my lord, this is the latest judgment, kindly have a look, my lord.
Which one?
My understanding. That is, my lord, the HS overall Limited Private Limited and others versus MMS and Gupta. Kindly, for my satisfaction. Very good, kindly takes up paragraph 6, my lord. Then paragraph 8.
So once the statute prescribes a mandatory time limit for filing a complaint, there cannot be any deviation from the same except where an application accompanying the complaint is filed seeking condonation, disclosing the reasons. Now, is it permissible as per the judgment, as per this particular, this is done, must have been done under the Negotiable Instruments Act. Now, in the Negotiable Instruments Act, does it say that you have to file an application? No. So wouldn't this judgment, no, Mr. Chaudhary, wouldn't this judgment be per incuriam the judgment of Sesnath?
For my understanding.
Division bench may help you.
I have understood.
Division bench will look into these new
Now,
judgments.
my lord, we'll have to
I
put
don't.
an amount of 55,000.
No, no,
One
no.
case, my lord, and my lord, around 75,000 more in one case, as your officer pointed out. That, my lord, the interest will be from the date of the order.
Only thing I can do is if he gives a concession of around 6% interest. But this 10% is statutory, na?
Statutory, my lord.
Fine, well.
So that is why, my lord, so now if he has the lordship has pointed out the other day, it will be from the date of the order.
Which order?
The order issued here, the
Ah.
order should be calculated because the lordship has pointed out that there was a delay of 4 years and there is.
That I'm. Although they are, because he has moved it very delayed.
My lord,
And that view of your lordship was, my lord, is supported by your earlier judgment in the Concord Bowman, which I pointed out. There also, my lord, there was a case of delay and your lordship has taken the That because there was a delay, so from the date it will not be applicable.
No, in fact, there is also another judgment of the Supreme Court, I think by Justice Ravindran, which I took note of in passing another judgment in the case of a pension. What is that pension?
That is Pankaj Brahma.
No, disability pension.
Yes.
In a disability pension, this person concerned he's from Nagaland. He was asked to means he was found out there that this person has epilepsy, and as such he cannot be continued in the Nagaland service. This police NP is here. This happened in the year 1991. Then he gave a representation sometime in 98. Then again he forgot. Sometime in 2009, he again gave a representation. Then in 2024, another representation was given. Then 25, the matter came up before me. So there I found that maybe he is not entitled to anything. He may not be entitled. He was asking for the other one. What is that? There are two pensions, no? Disability and other is? Disability is one, the other is when the authority asks them to go. No. There's another pension. Anyway, so he was asking that. So he cannot get that, but he was entitled to the disability pension. I gave him, but I put that his entitlement for areas will be only for 3 years prior to that, because of that judgment passed by the Supreme Court by Justice Ravindran. There's a thing now. So that is what. But anyways, how much is the interest?
My lords, my submission would be, my lords, as soon as the gratuity becomes payable, the employer has to give a written, notify me and the controlling authority under subsection 7, subsection 2. If that is not done within 30 days, so gratuity becomes payable at the time of my retirement. So if, and there is a mandate that employer has to give in writing to the controlling authority, that is the labor commissioner, and me, that gratuity has become payable. So under that thing, they have done is they've given 1 lakh, which is an illegal gratuity, because the statute is clear about the calculation of gratuity. They have given in their own internal rules and regulations that we will give gratuity for 1 lakh. So my submissions would be, as soon as becomes payable, then the interest, and if it's not paid within 30 days, then the interest has to be paid from the gratuity when the gratuity becomes payable. It is it is optional for me whether I go and file the application or not. The section 7 is clear on that aspect. I'm relying on a judgment of the Honorable Supreme Court, my lord.
Hey, payment of gratuity account.
It has been referred in the order. My lord, in those cases, is that, my lord, that the petitioners in those cases did not wait for, my lord, 4 years. Whatever was given, immediately they were. Here in my case, if I had given them 1 lakh, you have kept that 1 lakh, immediately you should have done, but you did not go within a period of 20 days because of specific time. And you waited for resolutions.
Mr. Chaudhary, I gave you a stay as regards interest on the ground that if you could negotiate. You failed.
Negotiation, my lord.
You failed. Once you failed, I can't
No,
help you
this is
any
my-
further.
I have just satisfied. my-
Didn't I, on the day on which I granted you the stay on the interest amount, didn't I tell you that?
You have a very tight case. You have a very tight case. So that is.
I am not only tight case, I was very clear on that. Let's see the payment of gratuity act.
Yes. Lordship may kindly come to, my lord, rule 8, that is my case, my lord.
Now, rule 10, let us first see the.
Rule
right
7,
of the
section 7, my lord.
Power to exempt compulsory 7, determinate. A person who is eligible for payment of gratuity under this act or any person authorized in writing to the act on his behalf shall send a written application to the employer within such time and in such form as may be mentioned.
My lord. My lord,
So it is for you to file that application.
my lords.
Okay.
Then subsection two, my lord.
As soon as the gratuity becomes payable, the employer, whether an application has been made out or not, determine the amount of gratuity and give notice in writing to the person to whom the gratuity is payable, and also the controlling authority specifying the amount of gratuity so determined. The employer shall arrange to pay the amount within 30 days from the date it becomes payable to the person to whom the gratuity is payable. If the amount of gratuity payable under subsidy is not paid by the employer within the period as mentioned in so and so, the employer shall pay from the date on which the gratuity becomes payable to the date on which it is paid simple interest at the rate of not exceeding the rate notified by the central government from time to time for repayment of the long-term deposits as the government may know. That no interest shall be payable if the delay in payment is due to the fault of the employee and the employer has obtained permission in writing from the controlling authority for the delayed payment on this ground.
That having not been done by the employer, my lords, in 2021 when I retired.
Sufficient, my lord, because as per our regulations and it was accepted by the employee, we paid them. So.
No,
My lord.
Mr. Sozi, don't make that submission. You cannot have a regulation contrary to law. These type of submissions doesn't befit you. So whatever you may have regulation, you may have many things, but the law makes it, the entitlement of gratuity is not because of your regulation. The entitlement of gratuity is in view of this act.
Yes, my lord, that is.
So
what-
therefore,
that is why I say we
therefore
will
your
be-
regulation, whatever may be, I'm not concerned with the regulation. The regulation has to be in terms with the act, and if it is contrary to the
Yes.
act, the regulation has,
I bow down
has the
whatever
doctrine
is
of a,
the
the,
doctrine of my lord. I bow down
provided
to
that no case interest shall be payable if the delay in payment is due to the fault of the employee and the employer. If there is any dispute to the amount of gratuity payable to an employee under this act, or as to the admissibility of any claim or in relation to an employee for the payment, or as to the persons entitled, the employer shall deposit with the controller such amount as he admits to be payable by him. Where is a dispute with regard to any matter or matter specified in clause A, the employer or employee, as the case we are raising, the dispute may make an appeal to the controlling authority concerning the dispute.
My lords, I'm supported by the Honorable Supreme Court judgment also, my lord. My lords, may,
These are all for division bench. But my question is here,
my lords,
you took that 1 lakh,
my lords,
right? Rightly, although you are entitled to more than that,
my
but
lords,
you took that 1 lakh. But you kept quiet.
my lords,
Thereupon you raise a dispute
my lords,
before the controlling
my
authority.
lords,
In the meantime, the controlling authority did not also do anything.
my lords,
Neither you raised the dispute
my lords,
that regards the amount
Mm.
for which they could have very well deposited that amount before them.
my lords.
But on the other hand, you accepted the amount.
That is prior to approaching the, my lords,
Understood? You accepted the
my
amount.
lords.
Now, after you accepted the amount, then after some years, you approach. Your right to the gratuity under no circumstances can be curtailed. That is my clear view. But whether is it your conduct out here
My lords,
that in this case you did not raise a dispute till then? As per them,
my lords,
they think that this is the gratuity. You see, if you see 7.2, as soon as the payable gratuity becomes the employer, whether an application is filed or not, determine the amount. They have rightly or wrongly determined the amount
My
of
lord.
rupees 1 lakh
my lords,
and then made the payment to you. Now, isn't it your fault out here that such interest, if it is a fault on your part as regards the interest,
my lords.
don't you think that this court can very well touch on that aspect?
my lord, in that aspect, my lord, my
I
submission
will
will
say, it categorically says that there is nothing else. If this proviso to section 3A was
lord.
not there, subsection 3A was not there, it's okay.
my lord.
But here it gives something.
My lord, but section 7(2) says that it is obligatory, mandatory upon the employer, my lord.
Yes, no quarrel with that. So therefore I say,
So,
them to pay that amount of 643, which is due to
my
you.
lord,
No quarrel with that.
my lord.
Your entitlement you are entitled to. There's nothing out there. But the fact remains that you kept that rupees 1 lakh.
My lord.
You kept quiet. All of a sudden, a dispute arose. When you raise the dispute, although there is a time limit out there, in my opinion, the time limit would not have any material bearing. A time limit, you filed a dispute. And on the basis of it, now it is being decided that 643 is the amount.
My lord.
Accordingly, now they have made the payment. Don't you think, therefore, does it say anything in the act that once it is decided that 643 is the amount,
My lord.
and you having not approached the court within time,
My lord.
would it be equitable on the part of this court to say that you are entitled to the interest from the date actually to be determined?
Yes, but in terms of the labor commissioner order, my delay was condoned,
So condonation is for filing an application.
my lord.
Condonation is not for the purpose of condoning your conduct of approaching the court later and for getting away with the interest.
My lord, in that regard, my submission will be the 1 lakh which was given, that is completely null and void in terms of the gratuity act. My lord, they had to follow the terms which were given under the
It's
gratuity.
not null and void, it is a part payment.
It was not said as a part payment, it was in their internal rules. It is said that we will only give you 1 lakh gratuity,
Understood. So
Right.
that will now have, after taking that 1 lakh,
my lord.
this commissioner out here say that look here, this 1 lakh is null and void, we won't consider, pay again another 643.
My lord.
They have taken into consideration
lord.
that's 1 lakh and say that deduct this and pay.
My lord. Yes. But the second part was not followed by them, my lord. They have given me 1 lakh. They had to inform the controlling authority also that, okay, we have given you 1 lakh. But if had they gone there, that controlling authority would have obviously objected to it because the gratuity itself was wrong. So that helps me in the section 7(2), my lord, in that. Because there were two, there are it is in two parts, my lord. They have to notify me.
Mr. Counsel, I'm
Well,
not saying that you are not entitled to interest, you are
My lord.
entitled. But you can be only entitled from the date you have filed the application,
My lord.
not
I'll-
prior to that. Prior to that, I think division bench will help you with these judgments. But in
Sir.
my opinion, you are only entitled from till date, from the date you filed the application. Because you have then brought it to the notice of the court or the controlling authority. Then look here, I've been deprived of this. And the controlling authority found that yes, it is. Take that. When did you file that application?
I filed the application on, my lord, 5/7/2024.
From there till now, you'll get the interest on that 10%. Not from the date of the order, from the date of the year.
They have made a payment on 26th September 2025.
So till then, 10% from the date on which you filed the application till the date of the payment.
My lord.
Keep that.
My lord, in 5543 of 2025, they will get a additional amount of 77,448. And my lord, in
Why?
It's from the date of the order that.
Not date of the order.
Date of the petition. Date of the petition, till my lord, this date. In 5543, it will be an amount of 77,448. And in my lord, 5542, it will be an amount of my lord, 54,147. So sorry, my lord, it will be 75,810. 810.
Let him look into that. Let's have it after vacation, but that is the order, which if the matter again comes back to me,
My lord.
I will only pass this order.
My lord, my only prayer is that these people have given their heart and soul to the school. They, at first, they deceived them by giving a false gratuity. Then I come to know when somebody else from a other school got the entire gratuity with interest. Then we approach, my lord. That is my submission, my lord. They have given 30, 40 years for the.
Are you therefore not, you therefore, well, wouldn't you come exactly within the bracket of fence sitter?
Unless that was a lapse on my part, my lord. So that was.
So therefore, from the date of your application, you raised the dispute.
My lord.
Till then you accepted it.
My lords, in a way,
You
implied.
accepted this 1 lakh till then. The moment you file an application, you have now raised the dispute. So in my opinion, that payment you are entitled. That is why you are entitled to, you have rendered so many years. Therefore, I said, I'm not going to grant a stay unless they pay that. So I gave them some time to pay.
My lord.
That is the only thing.
I'll leave that to the lords, my lords.
What?
That it will be taken up and this order will be passed. The applications matter for the.
You look into that.
Matter.
My lords.
You may have a luck that I may not sit in the reopening. Then you may have a luck of getting more. Coordinate benches, we may have a look at it. But otherwise, just find out from the date at 10%, what is the interest?
Well, as per the central government notification, it's 10%.
What is the interest? What will be the total interest from the date of the application to date of the?
Well, I have given a I have a calculation amount. Why not, in 5542, it will be from the date of application till the date of payment. It will be 81,681. And in the 5543, it will be 58,483.
88.
58.
58,000.
483. From date of application till date of payment, that is
Date of
26.
application date is
5/7/2024.
5/7/2024. And the other one is
Same, both we approached.
5/7. Why one is less?
Because the amount of salary was less.
Salary was less, basic pay and
So 81,681.
Not 81 in by, for my calculation, it will be 77,448. And in the other one, it will 50.
81,681.
81,681,
And the other is 58,483.
58,483.
Why are you fighting for this small amount?
No, I'm not fighting my lord.
Look, otherwise, it would have been from the date of retirement, it would have been 2,65,000 something odd.
That obviously there is a problem out there. You see, if you condone it, because yeah, that order also mentions that he came to know when there is somebody out there, then he came. Because otherwise, which means that you have accepted all along.
My lord.
But anyways, you have been good for other people also, no?
My lords. For the future, my lords.
So what should I do?
My lord.
Would you like to take a chance next year?
My lord, after having so much.
I'll leave that to your lordship, my lords.
No, don't leave it to me. I'll leave it to you. Otherwise, this court will direct you to pay this 81 and 58. If you are comfortable with this, I'll finish it off.
That's my submission. I've laid my submissions, my lord.
I've seen your submission.
My lord.
I've heard you. I've also explained you your
My
submission.
lords.
So what do you want? Do you want, I give you another chance if you want to.
I'll leave that to your lordship. That will be wise for your lordship to decide.
Chalo. Heard Mr. G. Chaudhary, the learned counsel appearing on behalf of the petitioner, and Mr.
N. Patiri.
N. Patil,
Patiri. P-E-T-I-R-I.
the learned counsel who appears on behalf of the respondent number 2,
Respondent number 3.
respondent number 3, and MCT appears on behalf of the respondent numbers 1 and 2. The petitioner herein have approached this court challenging the orders dated 4/3/2025 and 8/5/2025 passed in LPG case number 42/2024, whereby the respondents, whereby the petitioner, whereby the respondent number 2 had arrived at the finding that the respondent number 3 is entitled to an amount of rupees 7,34,123 on account of gratuity, and as an amount of rupees 1 lakh has already been paid, the petitioner is further required to pay an amount of rupees 6,34,123 along with interest at the rate of 10% per annum from the date it fell due. This court, while entertaining the instant writ petition and issuing a notice on 19/9/2025, categorically observed that the respondent herein, respondent number 3 herein, is entitled to the payment to the gratuity of rupees 7,34,123 in terms with the Payment of Gratuity Act 1972. And therefore, and as an amount of rupees 1 lakh have already been paid to the respondent number 3 earlier, this court directed the petitioner to deposit the amount of rupees, disburse the amount of rupees 6,34,123 to the respondent number 3 on or before 1/12/2025, isn't it? Full stop. The only issue therefore arises in the present proceedings now is as to whether the petitioner, respondent number 3, would be entitled to interest at the rate of 10% per annum from the date the gratuity from the date the only question herein which arises now before this court is as to from when the interest at the rate of statutory rate of 10% would be chargeable on the amount of gratuity payable to the respondent number 3. Mr. G. Chaudhary, the learned counsel appearing on behalf of the petitioner, had submitted that the petitioner is not entitled to any interest inasmuch as the petitioner had approached the controlling authority after a period of 5 years in the year 2024. The learned counsel further submitted that at best the amount due at best the interest at the 10% on the amount due can be calculated from the date the impugned order was passed. That is 4/3/2025, on which date it was it had, the controlling authority had come to, had come to an opinion that the petitioner is entitled to an amount of, the respondent number 3 is entitled to an amount of rupees 7,34,123. And out of which rupees 1 lakh have already been paid. Per contra, Mr. So-and-so, learned counsel who represents the respondent number 3 submitted that the holds and any application filed by the petitioner in terms with Section 7 of the Payment of Gratuity Act 1972. It is a duty entrusted upon the employer, that is the petitioner, to make payment of the gratuity payable to the respondent number 3 oblique the employee. Within 30 days from the date it becomes payable to the person. Within 30 days from the date it is payable. The learned counsel further submitted that a perusal of subsection 3A of section 7 would further show that if the amount is not, a gratuity amount is not payable in terms with subsection 3 of section 7, interest at the rate, simple interest at the rate as not exceeding the rate, simple interest not exceeding the rate notified by the central government from time to time for payment of the long-term deposits has to be paid. The learned counsel therefore submits that the period that the amount fell due upon the petition, was payable to the amount of gratuity was payable to the petitioner, respondent number 3. With effect from 1/5/2019, isn't it? 30 days. He's entitled to the gratuity upon his retirement.
Yes, my lord.
So 31/3 he has retired.
31/3. In one case, it's 2019.
Let us come to one
My lord.
case.
1/4/2019.
We will look into them.
My lord.
Don't worry. So 1/3, let us take one case where it is 634, 5543. Then my stenographers are able enough to make that correction. Okay, from 1/5/2019. In that regard, the learned counsel has referred to a judgment of the Supreme Court in the case of H. Ganga Hanumi Goda versus Karnataka Agro Industries Corporation Limited, reported in 2003 3 SEC, page 40. This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record. For the purpose of deciding the dispute in question, this court finds it pertinent to quote the provisions of sections, the subsections 1, 2, 3, 3A. Four. Four of section 7 of the Act of 1972. From a perusal of the above quoted sections, more particularly subsection 1 subsections of section 7, more particularly subsection 1 stipulates that the employee who is who is eligible for payment of gratuity is required to send a written application to the employer within such time and in such form as may be prescribed for payment of such gratuity. In the instant case, no such application, however, was filed. Isn't it?
My lord.
Be it as it may, it is very interesting to take note of subsection 2 of section 7, which stipulates that irrespective of such application being submitted by the employee, it is incumbent upon the employer to determine the amount of gratuity and give notice in writing to the person to whom the gratuity is payable, and also to the controlling authority specifying the amount of gratuity so determined. Subsection 3 of section 7 further imposes an obligation upon the employer to make arrangement to pay the amount of gratuity within 30 days from the date it became due to the person to whom the gratuity is payable. Therefore, a conjoint reading of section 3, subsection 3 and subsection 2 and subsection 3 of section 7 enjoins a duty as well as a responsibility upon the employer to determine the amount of gratuity payable and give a notice in writing to the person to whom the gratuity is payable, and also the controlling authority specifying the amount of gratuity so determined. In this regard, it is pertinent to take note of that the petitioner herein had determined that the respondent number 3 was only entitled to an amount of rupees 1 lakh and duly paid the same. Now let us go take note of subsection 3A of section 7. A perusal of the said section reveals that if the employer fails to make payment of the gratuity determined within 30 days from date the gratuity was payable, interest at the rate of 10%. Interest at the rate, a simple interest is to be payable as notified at the rate notified by the central government. It is relevant to take note of that the central government had notified 10% as the rate payable. The subsection to the proviso to section 3A, subsection 3A also mandates when interest is not payable. This is very important. In as much as This is important for the purpose of adjudication of the instant proceedings. In terms with the said proviso, if the delay in payment is due to the fault of the employee, and the employer had obtained permission in writing from the controlling authority for the delayed payment on this ground, then interest is not payable. In the backdrop of the above, the material, the facts, in the backdrop of the above, a perusal of the facts of the instant case would show that though the petitioner retired, respondent number 3 retired on 31/3/2019, the petitioner thereupon the petitioner, the respondent number 3 retired on 31/3/19. And the petitioner determined that the gratuity payable is rupees 1 lakh. The facts further reveal that the petitioner accepted the said amount. But when the petitioner realized that there were other teachers who have received much more amount
From different institution,
from
other institution.
other institutions, and the petitioner, but when the petitioner came to learn that similarly situated teachers in other institutions have received much higher amount. The petitioner, the respondent number 3, thereupon filed an application disputing the amount of gratuity paid to the petitioner. This application was filed on 5/7/2024. The controlling authority, that is the respondent number 2, had thereupon passed the orders dated 4/3/2025 and 8/5/2025, opining that the actual gratuity amount to which the respondent number 3 is entitled to is rupees 7,34,123, and as an amount of rupees 1 lakh has already been paid, the respondent number 3 is further entitled to an amount of rupees 6,34,123. It was further mentioned that further opined by the impugned orders that there would be also interest at the rate of 10% per annum from the date it fell due. In the opinion of this court, the petitioner, having accepted the amount of rupees 1 lakh without protest, having accepted the amount of rupees 1 lakh and did not raise any dispute till 5/7/2024. There was a delay in adjudication of the dispute, the adjudication, that there was a delay on the part of the petitioner in determining there was a delay which was caused by the petitioner in determining for actual determination of the dispute pertaining to what would be the gratuity amount payable in terms with the Act of 1972. At this stage, this court finds it relevant to take note of the judgment of the Supreme Court referred to by the learned counsel appearing on behalf of the respondent number 3, that is H. Ganga Hume Gowda, Supra, in support of the contention that the petitioner hearing respondent number 3 is entitled to the interest from the date 1 month, 30 days after the petitioner respondent number 3 had retired. In the opinion of this court, the said judgment cannot be made applicable, taking into account in the said proceedings pending before the Supreme Court, it was not the case of the employer that a delay is in payment of the gratuity was due to the fault of the employee, which is otherwise the case in the present case, which is otherwise the case of the petitioner in the present proceedings. Accordingly, it is therefore the opinion of this court that the impugned orders so passed by the respondent number 2 does not require any interference save and except a slight modification which is observed hereunder. Number 1, this court finds no infirmity in the impugned orders dated so and 4/3/2025 and 8/5/2025, passed in LPG case number 42/2024, in deciding as regards the quantum of the gratuity payable to the respondent number 3. Full stop. It has been submitted that the said amount, it is submitted at the bar that the said amount have also been duly paid to the petitioner. Number 2. It is the further opinion of this court that the petitioner herein is entitled to interest at the rate of 10% from 5/7/2024 till the date of actual payment of the gratuity. It is being submitted at the bar that the petitioner herein, the respondent number 3 herein, if in the respondent number 3 herein would be entitled to interest of an amount of rupees 81,681, taking into account that the principal amount, gratuity amount have already been paid on, what is the date?
26/9/2025.
26/9/2025. Full stop. Next. Accordingly, this court therefore disposes of the incident with petition, thereby directing the petitioner to disburse the amount of rupees 81,681 to the respondent number 3 within 15 days from the date of the present order, and thereupon file an affidavit of compliance before the registry of this court on or before 30/1/2026. It is further observed that if the affidavit of compliance is not filed, the matter be again placed before this court. The other one,
Other one is,
Same order.
wait, other one you help.
my lords.
Dispose.
Amount will be different.
My lords, in 5543, the date of retirement is 31/3/2021. And 554, the date of retirement, 5542, the date of retirement is 2019, 31/3/2019.
Now, one I have already
My
dictated.
lords. That
The
is
other
55
one is,
Other one,
one thing, anybody of you give him the details to him.
My lord.
When the retirement and how much they are entitled as per you, not as per him.
My lord.
The amount is 58,483. One is 81,681 and the other is 58,483.
58,483.
So dispose both.
Deeply obliged, my lord.
The lordship, item 38 was supposed to be listed on 28/01/26. They're supposed to be reset. And I've already informed the client of joining the Wakalat company. I've also informed the client, I've written letter, I'll file appropriate application for the joint of Wakalat. And in 37, your lordship, when against the ONGC's affidavit in opposition, we have filed a rejoinder. And respondent number 5 has filed an affidavit reply. Or affidavit in opposition just on 16. May I be allowed to file a short reply against that?
When?
Right? 5 days or 1 week. Your people not maybe listed on first week of January.
I think I should give you more time. We have it in the last week of January. Wait. No, you see, the problem is first week is only 5 days. First week is closed.
Right.
Second week, only 5 days is there. Third week is only 4 days. You like to go for a disposal, I suppose.
22, if it is not inconvenient.
22. Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner submits that the respondents have filed their affidavit in opposition. Respondent number 5 has filed an affidavit in opposition on 17/12/2025.
16. 16.
17.
We have-
You got it
17.
not 60. On 17/12/2025 and submits that some time may be granted for the purpose of filing the reply. So taking into account the above, list this matter on 22/1/2026 at 2 p.m. So in the meantime, reply be filed on or before 19/1/2026. Here,
This was the, item 38 was already fixed on 28th.
ready to Lekki Divo?
Perhaps,
The instant writ petition, তার হেতুতে লাগবে, instant writ petition is detached from WPC number 4594/2025. লিখি দিলে, তাকে এইখন দিব, এইখনত অৰ্ডাৰটো দিব, list on the date so fixed on 8/12, list on again on 28/1/2026.
Obliged.
May I please your lordship? The last occasion was passed in order. Accordingly, they filed affidavit. And in the affidavit, it reflects that they have supplied the chocolate notice within time to the my lord earlier secretary. who has also filed reply. And my submission is that, my lord, at this stage, that, my lord, the authority has not yet decided the fate of the, my lord, site license, number one. Number two, my lord, both the suspension order as well as the, my lord, show cause notice do not contain the, my lord, inquiry report, part of the show cause notice or the, my lord, suspension order do not form part of the inquiry report. So, my lord, this honorable coordinate weight of bench of this honorable court in an earlier proceeding has decided that, my lord, since the decision-making authority has taken a decision on the basis of the inquiry report, which must be a part of the record, or part of the record of show cause, they have not supplied. This is the judgment, my lord. Just for reference. Shows. Paragraphs 10, 12, and 13, my lord. Just I am referring. Both the order, my lord, show cause as well as the suspension order do not form part the inquiry report. Ten, 12, and 13, my lord.
Now, has their license been cancelled?
Not yet.
So it is being suspended.
Suspend.
Now,
Now, at that stage pending.
have they issued the show cause under 15.2?
Yes, that's
You have submitted a reply.
the earlier secretary. They have issued show cause to the earlier secretary, who has, my lord, replied also within time, my lord. And in July, they have, perhaps in October, my lord, he has replied to the show cause notice, but they have not yet decided. And these two, my lord, I am on, my lord, this show cause notice as well as, my lord, the suspension order do not contain the inquiry report. They have not supplied the inquiry.
Suspension order does not require an inquiry report. But for the show cause notice, they have to give you the inquiry report.
Yes, that is not there.
Now, whether the inquiry report has been given to you or not.
No, show cause, the lordship kindly see.
Okay, you do one thing.
That part will reveal from the records, Lordship. Otherwise, we have filed affidavit, Lordship. We have filed affidavit, Lordship. Yes.
The affidavit, my lord, their show cause notice is there, my lord.
On yesterday, we have filed affidavit,
Yes,
Lordship.
page 32, my lord. And
Yesterday, we have
this is
filed
show cause
affidavit.
notice. I'm sorry. This is the show cause notice.
And even, Lordship, that consumers are tagged with other
That
GPSs,
is there.
Lordship. There is no, Lordship.
I'm just forwarding it to the affidavit they supplied to us. This is the show cause notice. They are referred to the inquiry report, but they are not supplied.
Now, the inquiry reports are enclosed here. To the affidavit.
Now and go, but the show cause notice they have not.
No, it's okay.
Now in the affidavit they have supplied.
No, it's okay. Now,
After
what
filing this petition.
Mr. J.M.A. Chaudhary, let us do one thing. You now have the inquiry reports. I give you the liberty to submit a fresh reply on the basis of the inquiry reports.
Lordship.
Lordship.
And ask them to decide within 30 days.
There are-
Yes, ma'am.
Otherwise,
That is
also,
my-
Lordship, in the SOCOS reply, this was not the plea of the Lordship petitioner, Lordship.
Yes,
Yeah.
that is
Huh?
there. But
In the SOCOS reply, Lordship, in respect of the SOCOS notice, he has filed a reply, Lordship. In the reply, that plea was not taken by the petitioner.
It's okay.
Lordship.
They didn't
Just
meet
the
the-
indicate, Lordship, as per
They
his
did
submission.
not meet
But
Mr. J.M.A.
that should not
Chaudhary.
legalize their action, my lord.
Lordship,
If I am
Just-
not
yeah,
supplied.
Unnecessarily setting aside the inquiry again, asking you to
Yes,
do and issuing a show cause.
No, we have no
Now,
issue.
as of now,
Lordship.
he has the show reply.
Lordship, Lordship,
here.
Lordship.
Ask him to submit within 15 days
Lordship, Lordship.
his reply, if
Lordship,
any,
Lordship.
giving him liberty.
Lordship.
If he wants to submit a reply,
Lordship.
then you decide within 30 days.
Lordship, we have no issue. We have no
Yes,
issue.
ma'am.
We have no issue.
Better
Fair
we-
enough, but I-
Lordship, Lordship. We have
We close it.
Whatever
Lordship,
matter- yes, my lord, whatever
Lordship,
they
Lordship.
consider.
Lordship, Lordship.
With 10 days you submit. my lord.
I give you 15.
Because, my lord,
পয়সা দিব হলে 10 days নিদিব কিন্তু
Heard
Okay,
Mr.
well,
J.M.A.
no,
Chaudhary, the learned counsel appearing on
Mm.
behalf of the petitioner. Mr. K. Gogoi appears on behalf of the respondent numbers 1 to
Lordship,
6.
The five, my sister will appear, Lordship.
Okay. 1, 2, 4, and 6, and respondent number 5 ticket appeals. The petitioner herein has approached this court challenging the order dated 27/2024, whereby the petitioner's license was suspended
Yes.
and an appeal thereagain so filed by the petitioner on 21/2025 have not yet been disposed of by the appellate authority. And the delay on the part of the appellate authority in disposing of the appeal filed by the petitioner dated 21/2025. Full stop. It is seen that pursuant to notice being issued on 26/11/2025, and the order passed by this court on 3/12/2025, an affidavit in opposition has been filed by the respondent number 3 and 4. Mr. J.M.A. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that a perusal of the show cause proceedings so initiated in terms with section 515(2) of the Assam Public Distribution Order 1982, for short the order of 1982, refers to certain inquiry reports. However, those inquiry reports were not furnished to the petitioner. And in absence of the same, the petitioner had submitted the show cause reply on 19/10/2024.
My lord, the suspended secretary.
Huh?
Suspended.
The
I guess,
secretary we are concerned with you, no? The earlier secretary,
Yes.
the erstwhile secretary of the Bagmara, na?
Yes.
Bagmara SOR GPSS Limited had submitted the show cause reply. He therefore submitted that the entire show cause proceedings so initiated without serving the inquiry report is in violation to the principles of natural justice. He further submitted that in terms of clause 5 of the order of 1982, there cannot be an extended period. There cannot be a continued suspension beyond the period of 90 days. Mr. K. Gogoi, the learned counsel appearing on behalf of the respondents.
Section 15, that will be my lord. Lordship has referred to 5.
No, 15 refer.
Clause 15.
15 refer, clause 15.
Order, when you say it is not section, it's not an act.
Sorry,
Clause.
sorry on that.
Clause 15. Mr. K. Gogoi, the learned additional senior government advocate who appears on behalf of the respondents, submitted that the allegations against the petitioner are serious and serious of misappropriation, isn't it?
Lordship.
Of PDS quantities under the NFSA Act 2013. The learned counsel submitted that the respondents are not adverse to receiving another reply to the petitioner, taking into account that the petitioner now has the inquiry reports which have been enclosed to the affidavit in opposition filed by the respondent number 3 and 4 as annexure C and D. Full stop. This court have duly heard the learned counsels appearing on behalf of the parties and have also perused the show cause notice which was issued on 9/10/2024 by the Additional District Commissioner Borpeta. A perusal of the said show cause notice refers to a joint inquiry report submitted by Minar Hussain, Area Officer and Inspector, and Saurabh Boiswa, Sub-Inspector, FPD and CA, Borpeta. However, admittedly, the said inquiry report was not furnished to the petitioner. It is further seen that there is another detailed report submitted by the Assistant Commissioner, Borpeta, dated 18/7/2024. It is the opinion of this court that taking into those allegations, the petitioner herein should be given an opportunity to file an additional show cause reply by taking into account the inquiry report, which have been enclosed as annexure C and D to the affidavit in opposition filed by the respondent number 3 and 4. Mr. J.M.A. Chaudhary, the learned counsel submits for the petition, learned counsel for the petitioner submits that the petitioner would be submitting the reply within 10 days. The learned counsel also submitted that if there is a delay in disposal of the said show cause proceedings, it is seriously affecting the livelihood of the petitioner.
Society. Petitioner society.
Petitioner society. It is you who is filing. Why the society has not come?
Yes,
that is-
in capacity of,
Is the chair.
he is the number one
one
petitioner is the
the
chairman.
Chairman and number 2 is the society.
Hmm.
Huh?
Yes. The board of directors of the Bagmara DPS.
Is the society not a juristic entity? It is.
Yes, lordship.
If it is registered under the Cooperative Society Act,
Lordship.
then
Petitioner.
why the board of directors is not a juristic
Lordship,
entity.
lordship.
Anyways, let us not go to so much of technicalities. What is this? I see a
That part, lordship.
Chalo. Lively, the very business of the petitioner society is affected. So taking into account the above, the incident with petition therefore stands disposed of with the following observations and directions. The petitioners herein are given the liberty to file an additional show cause reply by taking note of the inquiry reports which have been enclosed as annexure C and D to the affidavit in opposition filed by the respondent number 3 and 4 in the present proceedings. Number 2, the said liberty is granted for a period of 15 days from the date of the present order. Number 2, the respondent authorities, more particularly the respondent number, who is deciding it? The 4 has issued, na?
Lordship, lordship.
Respondent number 3 and 4. Respondent authorities, more particularly the respondent number 3 and 4, are directed to decide the said show cause proceedings.
My lord, may direct the respondent number 4, then he will have a chance to appeal before the respondent number 3, lordship.
To the respondent number 4, appellate authority, how can it be
Lordship,
there?
if ADC, then lordship deputy
No.
commissioner.
How?
No,
No,
no.
this is
no.
the
It will-
rules.
No, it will go under 29 to
Then
the secretary.
Then it will be secretary. If below the, my lord, deputy commissioner,
Well, the
Because you see, the DC means the ADC.
ADC.
That, therefore, I'm directing both.
lordship.
Because if normally in all cases, if you see the DC means the ADC.
Lordship.
Directed to AR. To decide the said so cause proceedings within a period of 30 days from the date of submission of the show cause reply, additional show cause reply. So subject to filing the same within the period for which the liberty has been granted herein above.
Lordship.
Number 3. If in the circumstance the petitioner herein do not file the additional show cause reply within the period granted herein above, comma, the respondent number 3 and 4 are directed to dispose of the said show cause proceedings within 45 days from the date of the present order. Number 5. The instant was the Mr. K. Gogoi, the learned counsel who represents the respondent number 3 and 4, is directed to apprise the said respondents about the present directions so that due steps can be taken.
Lordship.
Oblige.
This is yours.
Yes.
Lordship,
Take it. Then you say that you gave it to the court and the court has kept it, so I don't have it. Huh?
you require our copy may be kept as a record. Lordship.
It's there.
It is there.
I read it from there on.
Lordship. Oblige.
Lord, in this case, I have received the instructions. আমি কোনদিনা পাইছো? ইয়াতে নাপাবি যিকোনো এটা লিখাম।
What is this?
Lord, this is instruction of the instant case, my lord. Initially, my lord, I got the brief in the month of November only, my lord.
I've asked you to file an affidavit.
True, my lord, true.
This is the instruction you were giving.
No, this is, recently I have received.
What is your challenge, madam?
If you please to peruse Annex 1, page 12, my lord.
For regular service. Interim order is going on. No. What is this? You can regularize. Regularize, don't regularize all these things, but you can't keep it first.
He was continuing as orderly peon. Now after.
Why you are not applying?
I have biology from 17 plus years. I have been continuing.
How many years?
17 plus years. This I was appointed.
17 minus 9 years? Minus these 9 years? Because from 2016 till 2025,
Except-
9 years is there. 9 years this matter is pending. My goodness. This is why the courts are not functioning properly.
I have been doing my duties, my lord. I've been.
You didn't have 10 years.
My lordship.
You don't have a 10 year.
My lordship, I have, when that one-time regulation was there 14/8/2025, on that time also on 21/2/2015, I have completed.
When were you appointed?
My lordship on 22/5/2005.
2000?
Five. At that point of when one-time review, at that time also I have completed 10 years.
Then why his name was not sent along with those people as per the government's decision in Upennath?
No,
Upennath is what?
Upennath will not come here perhaps, my lord. Upendas. Upendas will not come here, my lord.
Whereby they said that those 10 persons, 10 years who have done those works.
If I have understood correctly.
Upennath is 2017.
Yes, sir. If I have understood correctly, he was serving as orderly peon till date. Now, advertisement was issued, he challenged, one post was kept vacant. Now, after the decision of the Honorable Apex Court in All India Judges Association, now the status of this orderly peon has become an allowance, because there is a notification or standard operating procedure of this court, wherein it has been provided that the judicial officer who are willing to get the allowance, that is orderly allowance, they can engage them. So there is no post like, my lord, the orderly peon.
Attached peon.
Attached peon, my lordship, no.
Attached peon, orderly peon, same thing, my lord.
Orderly is British.
Attached is Indian, but the status is like he's attached to the judge as a peon.
That is different. Attached peon is attached means that is a peon which we had that case, you remember? Where he then was, that very officer made him regular without any advertisement.
But the fact of the matter is that, my lord, one post was kept vacant. That post have to be filled up
No, you fill up
regularly, my lord. There is no doubt about it.
Post cannot be in like this.
He may get a weightage, he may get some relaxation, age relaxation.
Fill
He
up
may get,
and give him some, what is his age now?
at the time of filing, 37 years.
Filing 37, 9 years, 45. Give him age relaxation. Well, that's all. Nothing here. You have no right for regulation.
My lordship, if, maybe, my lordship is already, I.
Madam,
Judgment.
Madam, good to say. Let me dismiss it. Division bench will help you out.
My lord-
No, division bench, on grade 4 peons, they have a very considerate view. So immediately after reopening, you file an appeal. What do you say, Mr. Das?
No, my lordship,
No. I think this is the best way out.
my lordship is already aware of all the judgments I know, but one judgment only, my lordship, judge who wanted to. So similarly situated persons who also getting back.
Where is the circular?
Yes,
Where is the circular? That they are appointing others?
no, my lordship.
What drives? What is
My
this
lordship,
drive business?
At point of time, one second. I have
At
completed
that point of time, these orders which were passed at that point of time, they did not look into Uma Devi and all.
at that-
Where?
I have completed 10 years, my lordship, and I have been doing my duties, though I'm attached beyond my lordship, I'm doing my duties under this.
So this judgment goes very much against you, the division bench judgment which you have enclosed.
It does not, my lordship, it says, after I was not considered, my lordship, this was. Fine.
Same order I can pass. Mr. Das, kindly see page 32.
32.
Yes, she's helping us.
And that is, Milord, this is quite reasonable order, Milord. This order is reasonable that he is entitled for weightage and
Only with this, B is not there.
yes, Milord. There is a reasonable order, Milord.
My lordship, till that process, B comes, my lordship.
You cannot ask that. You have no right. You cannot say that if they go for an advertisement, stop it. Those are days gone.
My lordship, C maybe, my lord, till the process is done, my lordship.
Or C will be there. Till the process is not there, you will be there.
Yes.
No,
Till the process.
the court should have passed that order only, C, interim order.
Hmm.
I think I should now remedy the mistake.
My
Chalo.
lordship, with due respect, C comes, my lordship, but till process some B effective, my lordship, I guess.
Immediately they will jump in. Don't you think so, Mr. Das?
Sorry, Milord.
Wouldn't you jump in immediately and go for recruitment?
No, I don't, we'll have to, because this post is lying vacant since
One post vacant is a very big thing.
9 years almost.
You see the problem, I tell you. Ali. You are getting some 9 or 10,000 or 15,000 maybe. Salary is 22,000 or 25 or 27,000 as of now. Now the problem which arises is, if the post is kept vacant, the state is not paying that amount.
Hmm. Exactly.
And because of you, a person or even you are not getting it.
Ultimately, substantial, whatever is there has to be in substance, whether either he or.
You can very well give some, what you call, relax his age.
Yes.
Relax his age. That is the only way.
And my lordship, with regard to C, it shall be given due weightage for your past service and experience.
Don't. Division bench has given,
Yes,
gives
yes.
me all this thing. Now, it is that you should be there. I don't want that you should be thrown out. If you can get it very well. But that is the only way out.
It cannot continue in this manner, Milord.
In fact, the matter should have been disposed of early. Maybe because of you.
Not
The
because-
problem arose because of you.
No,
If
no.
it is taking 9 years for the High Court to file an affidavit.
Honestly speaking, I came into picture only in November this year. 15-20 days back, I came into picture. I got this Milord file and all, to be honest. It was
Okay, I'm not saying Mr. Ichkedas,
correct.
but I'm saying about the High Court.
It was not regularly listed also. After 1 year, this matter came into list. Something like that had happened, Milord.
Hello. Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. H.K. Das, the learned counsel appears on behalf of the respondent numbers 1,
No,
3, and 4.
1, 3, and 4. Yes, madam.
Mr. K. Gogoi appears for the respondent number 2. The petitioner herein has filed this instant writ petition challenging an advertisement issued dated 25/7/2016 for filling up the vacant grade 4 post in the establishment of the Chief Judicial Magistrate Lokhimpur. and further have sought for a direction that the petitioner's services be regularized as attached peon with the subdivisional judicial magistrate Khodar, Lakhimpur, not Lakhimpur. Full stop. The materials on record reveal that the petitioner was appointed on 22/2/2005 on temporary basis as an attached peon to 1 Sri Mohendra Kolita Subdivisional Judicial Magistrate Khodar, Lakhimpur. Full stop. There's nothing on record as to how the petitioner's services were thereafter extended, more particularly when the petitioner's appointment was very much attached to that officer concerned. Be it as it may, the petitioner continued to render service. Full stop. On 25/7/2016, an advertisement was issued by the Office of the Chief Judicial Magistrate, Lakhimpur, not Lakhimpur, inviting applications from eligible candidates for filling up of four posts of attached peons, 1 post of chokidar, 1 driver. The petitioner, being aggrieved by the issuance of the advertisement and the non-consideration of his case for regularization, has approached this court by filing the present writ petition. Full stop. The records reveal that this court, by an order dated 20/12/2016, while issuing notice, directed that the respondents may go ahead with the selection process, but shall keep 1 post of attached peon vacant until further orders passed by this case in the case. The resultant effect is that till date, the post of attached peon in the establishment of the Chief Judicial Magistrate, Lakhimpur, has remained vacant. A regular post of peon in the Chief Judicial Magistrate here have remained vacant for the last 9 years. First, the matter came up before this court on 27/11/2025, wherein this court inquired with the Guwahati High Court as to why no affidavit has been filed. An undertaking was given that an affidavit would be filed on or before 15/12/2025. And this court therefore directed the present writ petition to be listed on 18/12/2025. Mr. Das, it appears something very fishy. Why on earth the Guwahati High Court has not filed an affidavit for 9 years? I think we should issue strictures. It's very strange.
For me. to
Why
say-
affidavit has not been filed? In a matter of this kind, why affidavit has not been filed?
Lordship says.
It seems that the court, for the Guwahati High Court, that let him continue like this.
It should not be some miscommunication maybe in between and the.
How
matter
can there be a miscommunication?
It will be difficult on my
Matter
part
came
to
up
explain
once
9 years.
before. Let me tell you why.
Because I think it was not
If
regular.
this is the state of affairs, you see, after 2016, matter comes up in 2018.
Yes,
where after 2 years, the Guwahati High Court Council says that he is yet to receive complete instructions. 2 years. Then matter comes up after 4 years, where the Standing Council of the Guwahati High Court submits that he has received instructions and affidavit would be filed within 2 weeks. 31/1/2022. On 11/5, strangely, without any affidavit, this court issues a rule.
okay.
11/5/2022. Then the matter comes up on 22/11/2024.
What happened on that day, my lord? On 20?
None appears for Guwahati High Court.
Actually, the previous council perhaps.
Then matter comes up before me on 27/11. See,
True.
22/11/2024, 27/11. So is it
Almost
the
up-
thing that when a case pertaining to an employee of the High Court comes, then it will be listed after 1 year or 3 years?
That should not be, my lord, because all
It
all other
appears,
cases.
appears from the
Yes,
conduct of
some
the registry.
peculiarity is there in this case,
No,
but
this is
in
a
other
very
cases-
sad state of affairs.
Correct, my lord. Correct.
Affidavit not filed, rule issued.
Rule could not have been issued without an affidavit, my lord. That was a wrong on,
How is
my
it?
lord. That could not have been, my lord.
It's a very sad state of affairs.
But my instructions, my lord.
Or if your High Court wants to absorb him, but why are you keeping him like this?
Look, that is also.
You
not
don't
there.
file your affidavit, that means you don't want to contest.
In a way, yes.
You
but
know very well the instructions were received earlier. That was a submission made.
I don't, my lord, that file is
No,
untraceable.
that was a submission made.
We reconstructed.
Yes.
Yes, correct, my lord. Correct.
So then if the instructions were received then and it was to be filed in 1 week, you don't file it.
Correct.
That is in 2022.
Correct, my lord.
Then
But what I confronted is
ask
that,
your Registrar General to keep him.
what I
Yeah.
confront,
You want to regularize him, regularize him. Ask the High Court to regularize these people out there. You do whatever you feel like.
I can only seek,
This can't be the conduct. If
Correct.
it was the conduct of a state government, we would have blasted him right and left.
but I can only seek apology.
It's a
for-
very sad state of affairs.
Yes.
How these cases are being done.
My lord, I'll ask
The
the
registry
registry.
should be taken note of how. Nowadays, I don't find any matters out there, the High Court matters. All matters which have come, it's
Lord,
almost finishing.
This is a learning lesson for me also, my lord. I have already asked the registry that you search for this type of cases. After this, my lord, I have learned that there are cases which are pending since long. I have asked the registry to prepare a list and get the matters listed, my lord. It should not happen.
I'm very disappointed.
Yes, my lord. I'm sorry, my lord. I can only ask apology for
First, this court have, however, no affidavit has been filed by the Guwahati High Court. In spite of the assurance. Next. This court have duly heard the learned counsels appearing on behalf of the parties. Mr. Ichkitas, Miss S.G. Purva, the learned counsel appearing on behalf of the petitioner submits that as the petitioner have rendered service since 2005, the petitioner is entitled to be regularized, and more so in view of the circular of the Guwahati High Court dated 31/8/2015, whereby those workers working in the subordinate courts and who have completed 10 years or more as on 14/8/2015 was to be regularized. The Learned Counsel as a one-time measure. The Learned Counsel appearing on behalf of the petitioner submits that this very aspect was not adhered to insofar as the petitioner is concerned, taking into account that the petitioner have already rendered more than 10 years as on 14/8/2015. Per contra, Mr. H.K. Das, the Learned Counsel standing counsel appearing on behalf of the High Court, had submitted that the said scheme is not applicable in squad the petitioner, taking into account that the petitioner was temporarily purely appointed as a attached peon and had no relation as a contingent worker. The scheme which the petitioner has been referring to is a scheme only insofar as contingent workers. The Learned Counsel further submitted that that the judgment so passed by the Learned Division Bench of this court, which have been enclosed as Annexure 3 to the writ petition, the Annexure 2 to the writ petition is squarely applicable. And this court may duly pass such orders, similar orders as per the directions contained therein. This court have given an anxious consideration to the respective submissions. From a perusal of the appointment order, it is seen that the petitioner's appointment on 22/2/2005 was specific to an officer, inasmuch as it was clearly stipulated in the said order that the services of the petitioner would be terminated as soon as the officer concerned is transferred from the station or otherwise, whichever is earlier. Under such circumstances, the petitioner could not have otherwise been continued in the office of, in the establishment of the Chief Judicial Magistrate, Lakhimpur, North Lakhimpur. There is nothing on record that the petitioner's appointment was on the basis of some form of selection. It is the opinion of this court that regularization can only happen when the appointment is irregular, but not when the appointment is illegal. The appointment of the petitioner in the instant case, if taken to be on a regular basis, violates the mandate of Article 14 and 16 of the Constitution. Be that as it may, this court cannot also turn a Nelson eye to the fact that the petitioner had rendered service for more than 10 years when the writ petition was filed. And thereupon also the petitioner is still continuing. It is no doubt. This court have also duly taken note of the Annexure 3 to the writ petition, which is the scheme. And in the opinion of the court that the said scheme dated 31/8/2015 cannot be made applicable insofar as the case of the petitioner. It is also, this court also, upon perusal of the materials on record, is of the opinion that the petitioner is entitled to a similar directions as was passed by the Learned Division Bench of this court in its judgment and order dated 9/4/2010 in various writ petitions, including WPC number 5003/2002. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. The posts which have been kept vacant in view of the interim order passed by this court dated so and so shall be forthwith advertised for recruitment of advertise. No, there you go. The respondents herein are directed to take immediate steps for recruitment and appointment. No, there you go. The post which is been kept vacant by this court on the basis of an interim order passed by this court be forthwith advertised, thereby inviting eligible persons to apply. Number 2, the petitioner having been rendering service in the establishment of the Chief Judicial Magistrate, North Lakhimpur, is directed to number 2. This court observes and directs the respondent authorities to permit the petitioner who is still working to continue till the said post is filled up by way of a due selection process. Number 3, taking into account that the petitioner have rendered service all this while, the petitioner is given the liberty to participate in the said selection process. And if the petitioner participate, his age shall also be condoned, and there shall be also due weightage given while carrying out the selection because of his past service and experience. With above, the instant writ petition stands disposed. Interim orders passed earlier stands vacated. Very said. What has happened in the meantime? Who is appearing for the High Court?
Senior Advocate appears Gossip and Anirban Gossip. Your Lordship.
What has happened? Pursuant to the direction of clerk, what has happened? Any report?
Yes, Lordship, we have received.
In view of this report, I think we adjourn the matter. We listed again on in sometime in the last week of February.
Lordship, we have no any copy about that report, Lordship.
Huh?
We have no any copy regarding that report, Your Lordship. That has been diagnosed.
I'll return the report
Lordship.
to you. Provide a copy. We'll keep it here.
Lordship.
Or is the High Court doesn't have the finances for making a copy?
Lordship.
Something like that.
A copy that is back.
The state have not given the
My lord,
finances to the High Court so that they can photocopy a report and place it before this court. The junior has made a submission that they don't have a copy of this report.
just now, yes,
We have
sorry, my lord,
discussed now.
just now they had, my lord, send it just few minutes back, my lord. So I have not gone through it, my lord.
Lordship, we don't know about the report, what has been in there, Your Lordship. That's why I'm.
No, it's okay. No, you see, they are proposing to make a pay rule.
My lord,
You see, what is required is to have a pay rule. That pay rule has to be sent to all the governors, the 4 governors. On the governors will look into those pay rules, which is with the state governments concerned. And thereupon, they are to give the approval as per 229(2). And thereupon it would only come into being.
my lord.
So now, as per the report, it could be seen, to work out the complete final for implementation of here in respect and submit the same to the respective state government for information and. Look on and submit the same to the government. Pursuant to the order passed by this court dated 19/6/2025, a report has been placed before this court by Mr. T.J. Mohanto, the learned senior standing counsel of the Guwahati High Court. Pustak. From a perusal of the report, it's seen that no rules, that the pay rules have not yet been made.
My lord.
The pay rules as required under Article 229(2) of the Constitution is yet to be drafted. Pustak. Considering the above, it is also seen that further deliberations are being taken up by the subcommittee so constituted by the Honorable Chief Justice. Pustak. Mizoram and Arunachal Pradesh, tell me why you have not nominated the principal secretary, commissioner secretary who will be representing the Mizoram and Arunachal Pradesh? Why you have not nominated till now? After the Chief Justice has formed the committee, are you not required to nominate? Huh? What? Where is your Advocate General? Huh? I saw him in the court today. Ask him, we'll take it up after some time, get hold of the Advocate General. And madam, you also take your instructions. And I think you need to nominate anybody. Let the Advocate General come. You have a look at the report, we'll take it after some time. Whether, and find out whether all the members have been nominated by the respective governments.
Let me verify.
Because otherwise what will happen is, without that nomination, they cannot go ahead.
fulfilled, my lord. It cannot be take any decision.
But this committee is for the purpose of formulating how the pay rules, it's like a pay commission.
Pay commission. They will decide and they will formulate, then
They
send it
will
to the.
formulate and then they will take it up, they will make the pay rules. Once the pay rules are made, it will be forwarded to the respective governments. All the governments have to assent to that. Then only the pay rules will come into picture.
Come into.
This is how the things work, as I understand. We'll take it after some time. Have a look at the pay. This. Mr. Pangi,
My lord,
your case also would be covered by this only.
my lord, my,
Now, Arunachal Pradesh, they have not yet nominated their person. So let me take it up with the Advocate General when he comes.
my lord, my lord,
We'll take-
my lord.
Have a look at that report. Chanmia. Oh, that Chanmia case. How do you take care of the inland vessel rules?
Yes, my lord.
Where is your senior?
He got fractured. Accident.
What do you want? Adjournment?
My lord, I have gone through the acts, my lord, the Inland Vessels Act 1917, as well as, my lord, the Control and Management of Ferries Rules 1968. And also, my lord, some judgments of this honorable court. It says, my lord, the rule 6, my lord, and 7 of two different rules, my lord, that subletting of lease is non-permissible. But in this case, my lord, the lease was not subletting.
Mr. Doctor, you have to understand a very important aspect. Prior to that, there was a big accident out here, somewhere here,
Yes, yes.
for which a suo motu proceedings were taken up by the division bench. When the suo motu proceedings were taken up, there was another rule being made by the state government, providing how these ferries will be taken note of. While these rules are there,
My lord.
there comes the Central Act, which is the new act. Now, this new act provides that these are the people who can look into it. It is the owner, because there you are not only the owner, the person who is going to operate also
Yes.
has to be issued a certificate.
Yes, yes.
Not only the operator, the person who are also, as if you see the rules of 2021, the person who concerned are going to be the boatman and all this stuff is also to be
Yes.
registered.
Yes.
Are you following these provisions? Because you see, we are concerned, this Inland Vessel Act was brought in for the purpose of safety of the passengers. And this is one of the prime consideration which needs to be taken by the PNRD department. You cannot allow anybody.
My lord, in my humble submission, my lord, that is a curable defect, my lord, because in this case, present case, the petitioner himself is not a valid bidder, my lord. He cannot challenge this, my lord. As my affidavit is saying, my lord, police report has not been submitted. He is an invalid bidder, my lord. Whether he can challenge it, my lord. Because this is a curable defect, we can give the lessee to register with the authority, my lord, his name, my lord. But whether that can be challenged by this petitioner, my lord, that is the question before this law, my lord. Because he himself is not a valid bidder, my lord. And that is a curable defect, my lord. He can register, my lord, if law permits, my lord.
That's not a curable defect. But
My
the
humble
fact is, the petitioner being not legible,
Invalid.
he cannot be, econ no, econ purona. This is an old land. Now you have econ. Econ ek course. Econ. Now, the petitioner being not technically competent, he cannot challenge an LOI. This is the proposition you are.
Yes, my.
But even he is also not very malord.
First, you have to be technically competent, na? Why should we challenge at the, why should we set aside something at the behest of another competitor who is not technically competent? Tell me, if you are technically competent, very well. If it is a question of bid and all, it's a different thing.
Yes.
But if you are not technically competent, you did not submit that certificate. Clause 18,
Yes. Police report.
we adjourn it. Don't want to dismiss in your hands.
My-
I've not passed an interim.
Yes, ma'am.
Well, let them run it.
My lord.
Mr. H. Borua,
DK Burman.
V.K. Borua appearing on behalf of the petitioner submits that Mr. K.K. Day, the learned counsel appearing on behalf of the petitioner, had suffered a fracture and as such some time is required. Taking into account the above, what fracture?
Leg, the toe,
Huh?
the toe, my lord, fingers.
How many days?
After vacation, 2 weeks.
On 29th of January 2026.
High level.
But you need to take, sir, you need to take up this issue
yeah, my-
seriously, yeah?
My lord, my.
Because someday something happens.
Yes,
It
yes.
won't be proper.
My lord.
But if I dismiss his case also,
My
I
lord.
will also
Yes, yes,
direct
that is-
for you
That
to
will be very
take
effective.
it up.
My lord.
Because this is a very serious issue.
Yes,
Where is PHE, not PHE, the PNR? You find out here,
My
there
lord.
was a direction passed by me.
My lord.
You see, this tender I set aside
My lord.
on 12/11/2025, which was made in favor of the respondent number 7. Okay,
My lord. My lord, I can take notice, my lord, or she may issue short
No.
notice, my lord.
I don't issue notice contempt like this. First, I give you an opportunity. Comply?
But if lordship will issue notice, my lord, I'll make it.
I don't issue. Because once I issue notice in a contempt, it becomes very difficult to close it.
Mine.
So therefore,
I
I
understand.
give you opportunities, one more. What action have you taken pursuant to the
Mine.
directions in paragraph 17, Roman 2?
My lord, my lord.
First has already been done. Second, you may go for a fresh tender.
My lord.
You may go for a fresh settlement, or you may give it to the highest bidder, whatever it may be.
Yes, yes.
What decision you have taken?
My lord, my lord.
That's all.
My lord.
Nothing more than that.
Okay.
The instant petition has been filed alleging willful and deliberate violation to the order passed by this court dated judgment and order passed by this court dated 12/11/2025 in WPC number 4561/2025. Full stop. The directions which were passed by this court were twofold, as it appears at paragraph number 7 of the said judgment and order. So paragraph number 7 and 17. Paragraph number 17 of the said judgment and order. Full stop. The said paragraph is reproduced herein under. Taking into account that Mr. S. Dotto, who is the standing counsel of the PNRD department, was also the counsel who represented the PNRD department in the said writ proceedings. This court have requested Mr. S. Dotto, the learned standing counsel of the PNRD department, to inquire from the department as to what steps have been taken, more particularly in respect to the directions given in paragraph number 17, Roman 2, and apprise this court. First up, a copy of the petition be furnished to Mr. S. Dutta, the learned standing counsel of the PNRD, which would, so that he can obtain the necessary instructions. First up, the name of Mr. S. Dutta be reflected in the cause list. First, list this matter again for motion on 9th of January and 7th of January 2026. You just find out if you
Yes,
have
yes.
taken any actions, we close
lord.
this.
My
Because issuing notice is different.
I'll suggest my client.
These are also, these people are also troubled by the
My
issuing
lord, my lord.
notice.
I'll suggest. I'll oblige.
And if not, you take the action.
My lord.
EK Medi submits that he be given to file interlocutory application. Then what?
On the right of context, petition.
2 weeks has gone now. Order of 2019, let us see what is the order.
Page 7. Operating part of also. 8.
In view of the stand taken by the health department, as it is seen from the supplies made by the petitioner is not in discovery inclined to allow the by directing the issuance so to release the outstanding within stream from the receipt of the order. Where is the receipt? Where is the receipt of this order? Huh?
Page 4, your lordship, columns.
What page?
Page 4, your lordship.
What page 4?
Paragraph 6, your lordship.
What?
May I read your
No, where is the receipt?
receipt?
You see, from the receipt of the order, they will pay. Where is the receipt?
They have received.
No. Where is the receipt enclosed? You see, this is the quasi criminal proceedings. One has to be very strict. Where?
Page 4.
No. Where is it? The document, receipt.
Thus they have given a number, your lordship, receipt number, your lordship.
What number?
416.
How did you forward it? How did you forward it?
Himself of the people submitted the.
So you gave a forwarding letter
Yes, lordship, along with the.
and you didn't take a receipt.
Thus they have given number, your lordship.
What?
Yes, lordship, can you see the paragraph 6, your lordship?
No, you can't go by that. Where?
The last line, your lordship, issued the receipt number 416 of the 2019, your lordship.
Para?
Para 6, your lordship.
3 months from the date of Iman. Where is the receipt number?
416, your lordship, paragraph 6, your lordship, page 4.
Applicant and the respondent, namely so and so, received the certified copy by issuing a receipt number so and so. Who has received it?
According to this, your lordship. Thus he will be given a number, your lordship.
Can't help it.
That is, your lordship.
Health department, find out anybody from health department if you have any success.
In this case, new incumbent joint has my lord, 17 affidavit, Sonal Highway.
What?
In this case, my lord, new incumbent joint has 17 affidavit for National Highway, my lord. Accordingly, we have submitted our representation
on 3rd September, my lord, 2025. And hereafter, my lord, I have the instruction that file has already been forwarded by the chief engineer to the district commissioner, Bozali. But it is yet to be paid. So, my lord, we have already submitted a representation before district commissioner Bozali also. Now, my lord, I require 2 weeks time to, my lord, implement the district commissioner Bozali.
I give you 6 weeks.
No, my lord, that was, for my lord, at that time, the file was pending before the, my lord, chief engineer PWD. That has already been forwarded. Respondent number 12 was there, my lord, earlier.
Where is the direction?
Directional page 15. my lord.
Till now, nothing has been done.
My lord, already forwarded by chief engineer, my lord, PW to the district commissioner Bozali, my lord, for payment of the compensation, my lord, but it is yet to be paid.
You have not received.
No,
Your land has been taken.
my lord.
Where is the government council? Yes. Take instructions. What is happening in this case? Give a copy to him.
My-
It is seen the petitioner herein is aggrieved by the willful and deliberate violation to the order passed by this court dated 27/2/2018. Passed in WPC number 2411/2012. By the said order, comma, there was a direction issued to the Deputy Commissioner Borpeta to take immediate steps for preparing a correct and authenticated assessment of the amount of compensation that is required to be paid to the writ petitioners, and thereafter send a report to the Chief Engineer PWD NH Works Division within a period of 3 months from the date of receipt of the certified copy of the order. Full stop. It was further mentioned that upon receipt of the proposal from the Deputy Commissioner, comma, the respondent number 6, that is the Chief Engineer PWD NH Division, shall take necessary steps for releasing the payment within a period of 3 months thereafter. Mr. Counsel, this order cannot be complied with.
But already, my lord,
This order is absolutely perverse. I tell you why. Who is to pay the compensation?
ultimately, my lord,
No, ultimately, no. Who is to pay the compensation?
revenue department, my lord, because revenue department, my lord, because, my lord, the fund will be.
Mr. Counsel, you have to know when you are doing a matter. Payment of compensation is to be made if it is done under the Land Acquisition Act 1894 by the district collector. Okay. Who is the requiring authority?
PW.
The PWD. The PWD has to make the payment to the state.
Yes.
To the collector. The collector will pay. It's the other way around. It is the absolute opposite. Here the deputy commissioner is directed to make the assessment, correct assessment, and send it to the PWD to PWD will pay. Tell me, how is it possible? Tell me.
Perhaps, my lord.
Can the PWD be directed to pay? If the PWD makes any payment, that payment would weigh very much. That is the problem which is being faced by you. This order cannot be complied with. You do one thing. You file an IE. Not here. In that writ petition. For necessary modification. then appropriate directions can be passed. Okay? That you do it. This cannot be done. This is absolutely perverse directions, with due respect.
Some similarly situated person has already received.
Huh?
Some similarly situated person, my lord, already received,
Of the petitioners.
not petitioner, some other.
Therefore, I'm not on others. I'm only concerned with these. So you therefore file an IA that there is a big problem out here. That look here, direction is given to the chief engineer to pay. It's an acquisition being made under the Land Acquisition Act. It is the deputy commissioner who has to pay. And the chief engineer should be directed, not the chief, the PWD department is being the requiring authority. They have to deposit the money before the chief, they see. This is what I know. And what do you say, Mr.?
Yes, madam.
Huh?
That is correct.
Required department has to first deposit the amount, then it is dispersed by the.
You do something. Think about it. Being the last 2 days of this year, I'm giving you an advice. Otherwise, bad case. This you can't comply. No, nothing. Okay. But you, okay. The learned counsel appearing on behalf of the petitioner submits that some more time is required for filing the implement application. Full stop. Taking into account that this court have granted various opportunities and there appears to be no urgency, list this matter only upon filing of the application for implement. In the meantime, where is the other one? এইটো কোনোবা এটাক বিচাৰিছিলো না আগৰ কেছটো আপে ল'ম বুলি ক'লো যে এটা কন্টেম্প এটা আছিল which was the department? Huh? কি ডিপার্টমেন্ট আছে PWD or health দূৰত নাৰাখিলো তো health. The moment we see health, I saw, yes, he is there. You see, in this case, the matter is unnecessary getting delayed.
Lordship,
And he's taking time after time.
Lordship,
But the fact remains that there is a direction passed by this court.
Lordship,
Wherein, kindly see the order, give it to him.
Lordship, I have the petition.
You got a petition?
Yes, Lordship.
Kindly see paragraph number 3.
Lordship,
The learned counsel for the Directorate of Health Service has produced a copy of the instructions received by her, by virtue of which Additional Secretary so-and-so has moved the Commissioner and Secretary so-and-so for releasing payment to the petitioner. This was in 2019.
Lordship,
And therefore, there was a direction to do so within a period of 3 months.
3 months, Lordship,
Here, the petitioner has received the money or not, that is not known.
Lordship.
Petitioner have also not taken proper steps.
Lordship.
But whether it has been complied with or not,
Lordship.
that have a look.
Yes,
Lordship, similar matters also pending a lot.
What?
Other matters pending, same material also, same, contempt, same petition also. Same contempt petition also pending also. Two contempt petition, this is one, another is pending.
Mr. Medhi, don't try to take more advantage than what I am being given to you. Mr. A. Solia, who is the standing counsel of the Health Department,
Lordship,
is directed to obtain instructions as to whether the order passed by this court dated 13/12/2019 in WPC number 5886/2017 had been complied with or not. Full stop. If it is not complied with, comma, Mr. A. Solia, the learned standing counsel of the Health Department, shall provide the details of the present incumbent who is holding the post of the respondent number 6 in WPC number 5886/2017 on the next date. List this matter again on 19/1/2026. Yes, converted into contempt. What is this? Mr. A.R. Agarwal, what is your matter? We don't see you here.
case the party lordship from Delhi lordship. So taking steps is not serving the police. So police can be issued notice. That's why we agreed to pay the amount lordship. And we are having their WhatsApp number also. They are availing the service lordship.
You have not taken steps.
Taking step
When?
15, 12, what is there? Lordship, it is not served the time.
15?
12 lordship, but the office not make any decision lordship.
15/12/2025. You have taken steps. Why?
Answer on the office return, no such person.
Then? Okay, you do one thing. He's from Delhi.
Yes, sir.
You publish in Times of India as well as also in Hindustan Times and also in Dainik Bhaskar. Then you will get that 1 lakh rupees.
No lordship.
Huh? What? 1,50,000 you are fighting for that published there.
Much higher.
So what should I do?
WhatsApp or this.
Huh?
So police or WhatsApp lordship, mobile number I am having their mobile number.
So?
Through WhatsApp I send the notice.
WhatsApp you send them.
In their WhatsApp or from police or what's
How do I know that is the WhatsApp number?
the name appears, so they are having the correspondence.
Oh, it appears Truecaller.
Yes, please.
Very funny, very funny. Okay.
Possible lordship to yes, please.
It was closed, na? Contempt proceedings? Contempt proceedings have been, the complaint was quashed.
They agreed to pay the amount. They've agreed to pay the 1,50,000. Hold that down, it is possible. Page number 18 lordship. They appeared.
Who appeared for the earlier? Huh?
Just be Roman lordship. And then KG.
Now he has become a judge.
Yes.
Then you have, means good.
No way out. Lordship.
No way out to catch him also. Now you publish, you have to go for take service by way of Dusty.
That's because they are also not
Then you file it something. If it is going by postal, it is not happening.
Yes.
Go for Dusty.
Dusty and through WhatsApp lordship. Both.
Huh?
Dusty and WhatsApp lordship. WhatsApp.
WhatsApp, no. WhatsApp first you have to ask the Chief Justice to formulate a committee. The committee will then will frame rules for permitting by WhatsApp on the basis of a Truecaller number, and then we'll permit. Okay?
Dusty.
Dusty. Mr. A.R. Agarwal, the learned counsel appearing on behalf of the petitioner submits that pursuant to the order dated 3/1/2025, the petitioner had taken steps. However, the same had returned on the stating that there is no returned stating that there is no such person. He therefore submits that the petitioner would like to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. List the matter on 16th of March 2026. In the meantime, the petitioner is directed to effect service by way of dusty in the aforementioned by Hetu line kita lagai diba, and file an affidavit of service. Yes, Mr. Hussain, you don't appear otherwise. Today you are appearing. How many non-appears for the petitioner order has been passed? What is the order?
Phase 15, they started from this 15.
Deliberate violation of the order of 2019.
Yes.
2019. What is the direction?
Direction, phase 26.
Therein the district legislature shall take up the claim of the petitioner for victim compensation under Iman and after due inquiry decide the quantum to be awarded in terms with the government notification within a period of 2 months. Then you have given it to district legal services. Then what happened? Who is appearing for district legal services?
So on appeared, my lord. But, my lord, record source, my lord, report was submitted by the secretary, the election history, my lord. Wherein an order was annexed, my lord, annexer, I,
You have to challenge this order.
because
You have to challenge this order. Without this, I can't give you. Hence, there is no scope of violating a direction.
yes, my lord.
When so dispose of the proceedings of a Iman and the claim considered not tenable and hence rejected the application by the order dated 21/9 by the predecessor and the compensation awarded to the wife.
Yes.
Hence, there is no scope of violation to any direction. So,
My lord, our case, my lord, the wife already got second marriage, my lord. And this is the documents, my lord. Although those documents are available on the record of the secretary, DLS, my lord, but this order has passed.
Mr. Counsel, have you challenged this order of 21/8/2019 or not?
Because this order.
Lekho. Heard Mr. M. Hussain, the learned counsel appearing on behalf of the petitioner. Full stop. The instant application has been filed alleging willful and deliberate violation to the order dated 3/4/2019 passed in WPC number 1547/2019 whereby the direction was issued to the District Legal Services Authority Dhubri to make necessary inquiry and decide the quantum of compensation to be awarded in terms with the government notification dated 1/2/2019 within a period of 2 months from the date of receipt of the certified copy of the order. It is seen that in pursuance thereto, the District Legal Services Authority have duly taken up and made the inquiry and passed an order on 21/8/2019 whereby the compensation has been awarded to one Nasiron Bibi, isn't it?
Yes.
And thereby rejecting the prayer of the petitioner.
Not rejected, my lord, only awarded 2 lakh rupees to on Nasiron, my lord.
A legal hair certificate submitted is hereby rejected and submitted. Circular officers here, so and so. For submission of the legal aid by suppressing material, this authority is not inclined to ever to Abdul Manan of the rejecting the claim of the petitioner. Full stop. Taking into account the above, it is the opinion of this court that the order passed by this court dated so and so in WPC number so and so have been duly complied with. Accordingly, the instant contempt proceeding stands closed. However, the liberty is given to the petitioner if so advised to challenge the order dated 21/8/2019.
10 on 2021.
Huh?
Annex 5 of the record, my lord. 10 on 2021.
Challenging the order
Annex
dated
5.
26/2.
My lord, 10 on 2021.
Now the disputed by the Abdullah. A2 challenge question, therefore the question to be decided and deadlines as directed by Riyadh, we have paid for a month as to how the victim shall be paid. Copy. The authority passed to on India and with a copy of this order.
Annex 5, my lord.
It has been given to whom?
2 on Nasirun, my lord.
So you have not been given.
Not,
So on the basis of that order,
yes.
so I do the liberty need you challenge. No liberty.
My lord, liberty may be given.
No liberty. What
Because-
were you doing all this while? Next.
That's my lord,
No liberty, Mr. Hussain. No liberty, ekdam. No liberty. Should I put it?
my lord, liberty may be given to silence, my lord. My lord. God bless.
AFDC, anybody is there? None has appeared on behalf of the petitioner. Further to that, it is seen that the service have also been not meted out upon the respondent numbers 1, 2, and 3 till date. So considering the above, it therefore appears that the petitioner have not taken any interest in the instant contempt proceedings. Apart from that, this court also takes note of that the order which was passed on 11/1/2021 in WPC number 5057/2020 was only an interim order. So considering the above, this court therefore drops the instant contempt proceedings.
Lordship, as he has left, Lordship.
Okay. Appeal listening the order to Lagosinas. Now, pursuant to the order passed by this court on 18/12 to on so and so, a report have been placed before this court by the Registrar General of the Guwahati High Court. A perusal of the report reveals that the draft pay rules is yet to the pay rules as contemplated under Article 229(2) of the Constitution of India is yet to be drafted. Full stop. It is also seen that the subcommittee so constituted by the Honorable Chief Justice is further deliberating on the issue. Considering the above, list this matter on 23/2025 for an update. Full stop. This court further. Have they appointed this Mr. Monta, from that report, it appears that the Mizoram and Arunachal government have not appointed that so and so.
Notice this, notice were sent, and so far as my lord, Mizoram and Arunachal is concerned.
I think
Nagaland
they will
appoint,
take it up on the administrative side.
my lord.
Chalo.
Nagaland appoint, Nagaland they have already sent.
No,
their application.
Nagaland, Assam is there. Because you see, later on, this problem is going to
Yes,
happen.
ma'am.
Later on, both of you don't say that you were not there.
20th October model code of conduct may come into force.
But court order, no problem.
What does model code of conduct has to do with the framing of rules by the High Court? Are you saying that the High Court is influenced by these elections?
The government machine.
So what? They are to appoint, it is on regards of, you see,
The
that
committee.
is the
member of
main
the com-
problem which is happening. That is why it has been going on from 2001. We, as a High Court, after having spent 77 years, we don't have a pay rule. Isn't it the most shameful thing which can happen to a High Court?
No, because of the, my lord, the disturbance of the finance department, they have the environment.
Again, you are all pointing out at the finance department. First, you make your rule. Where is your rule?
The rule, 2013 rule has been sent, my lord. That was, my lord, because of the, it is returned back because of the financial implication, my lord.
Why you are only concentrating in the state of Assam?
Oh, that, yes, that's true, my lord. That is on state of Assam.
It has
No,
to, are you forgetting that this is a High Court of 4 states?
yes, four state, but other state, whether they will agree or not, because in, probably in Arunachal, they are getting higher.
Whether they agree or not, that is immaterial. Is the Guwahati High Court therefore saying
My lord.
that the persons concerned in Arunachal or anybody or any other place who are there, we don't have any power upon them? Are they not going, are those judges or the registers there not competent to address as to what is the work they are doing it?
My lord.
It is not for the states to decide as to what type of work these officers are doing.
No,
It is not for them. They are to only, even they can't look into many aspects as regard those finance.
yes, there's a
That
letter.
is
I have
this-
seen the letter, my lord. They have seen the letter also by the, from the finance department. They will send some query. That is the letter. they have sent.
So that is, has to be done. You see, if you see the West Bengal judgment,
Yes.
it is to be creased out by the Chief Justice. But first you have to make the rules.
Yes,
na.
first. I think this time, my lord, that will be done because all are except Nagaland and Mizoram, all are my lord representative there in his department. Then they will do it.
Chalo,
Deeply.
next.
See, here the order has been complied with by order of speaking order also.
Order complied? Order. Oh. This is an application. Heard Mr. S.K. Das, the learned counsel appearing on behalf of the petitioner, and Mr. N. Upadhyay appearing on behalf of the respondents. Full stop. The instant application has been filed alleging willful and deliberate violation to the order dated 19/8/2020 passed in WPC number 431/2019. Full stop. It is seen that by the said order, there was a direction upon the respondent authorities to consider the claim of the petitioner for the balance amount of rupees 902,881, and the said consideration be given along with other claims before the department in order of preference of the claims. Full stop. In pursuance thereto, a speaking order was passed on 13/6/2025, holding that the petitioner is entitled to only an amount of rupees 32,264. Full stop. A copy of the said order was also sent to the petitioner in that regard. Full stop. This court therefore, the said order copy have been placed before this court, which is kept on record and marked with the letter X. Under such circumstances, this court inquired with Mr. N. Upadhyay, the learned counsel who represents the respondents, as to whether the amount of rupees 32,264 have been paid to the petitioner.
Lordship, that I have inquired with the concerned executive engineer, Lordship. He told Lordship the petitioner is not communicating with them, Lordship. His Lordship,
Full stop. Taking into account the above, list this matter on 7/1/2026, on which date Mr. N. Upadhyay shall provide the respondent shall prepare a demand draft of the amount of rupees 32,264 and place it before this court in the name of the petitioner.
Lordship.
Full stop. This court further observes that the petitioner herein, if he is agreed with the assessment determination of the amount, is agreed by the speaking order dated 13/6/2025, liberty is given to the petitioner to file a civil suit before a court of competent jurisdiction, and a period during the pendency of the writ petition till 13/6/2025 be excluded while computing the period of limitation. You'll get the check. We'll give it to you on the next.
They have cited that due to non-recorded of two items. Lordship, this,
Aha, that I can't decide, Mr. Das. I can give you this much. I have given you more. These are normally, I should not, but I'm giving you. We'll give you
Right.
the check. Demand draft. What is this? Steps taken. Why the matters come up? Item given itu? 22. Service not complete. Which is the department? He's there.
Lordship, in fact, the respondent number 2, my friend has impleaded, he's already retired, Lordship.
Who?
The respondent number 2, he has newly impleaded. He is also been retired, Lordship, now.
It's okay. Why haven't you taken up this issue? You are directed to pay within 4 months along with interest.
I'll take instruction, Lordship, from the present incumbent, Lordship.
The standing counsel of Mr. N. Upadhyay, the learned standing counsel of the irrigation department, who represents the respondents in the present contempt proceedings, as well as was also the counsel for the respondent irrigation department in WPC number 7353/2018, is directed to obtain instruction as to whether the order dated 6/10/2020 passed in WPC number 7353/2018 have been complied with or not, and if not, the reasons therefore. Full stop. List the matter again on 9/2/2026.
Lord, Avalai.
None appears on behalf of the petitioner on call. It is further seen that the petitioner had taken time to implead the necessary parties on 2/4/2025, and in spite thereof, the petitioner had not filed any application. So it therefore appears that the petitioner is not interested in the instant proceedings. Further to that, it is also taken note of that the present respondents are no longer present respondent is no longer serving as the settlement officer of the Dhubri and Kokrajhar district. Consequently, the instant contempt proceedings cannot further be proceeded with. Accordingly, the contempt proceedings stands dropped.
I know the direction of the page 12 to verify the amount
claimed by the petitioner of 6,07,820. The direction, my lord, is in the last paragraph, my lord, that's the page 12. That's having not been done much.
Yes, why haven't you paid?
Lordship, one affidavit has been filed, Lordship, on behalf of respondent number 2. Lordship, so far as the status is concerned, while he was working as the executive engineer at Nalbari, Lordship, he forwarded a proposal and ultimately that was forwarded to the health department, Lordship, because it was their work, PW only executed the work. So from their side, no response is coming.
Whose?
Health department. And health is not a party. And so far as the respondents are concerned, Lordship, my friend is appearing for respondent number 1. I think he has retired.
Yes.
And respondent number 2 is concerned, in 2023 itself, he left Nalbari, Lordship.
Health was not a party?
That
No.
was not a party, my lord. In the written also, the lordship is trying to come to page 11. Page 11 is the recital form.
How do I help you?
Hello?
How do I help you?
So, in fact, the relief can be granted to me by the PWD because this is what they have claimed, my lord. The issue that has arisen now is that they have retired from the.
No, that is not the issue.
Or they have transferred.
What I'm submitting,
The
Lordship,
direction was
work
responsible
pertains.
in the writ petition, my lord. Direction which was given, my lord. The direction was to the respondents, my lord, at page 12, the last paragraph.
But why did your standing council did not mention then in that order? You have a standing council.
Yes.
Okay, you don't appear. Mr. B. Gogoi, you appear in this matter. You have made this submission before this court in this contempt matter. Kindly see the order dated 8/3/2021. Page 12.
So PW
Now, PWD is taking a stand that you see this is the case of the health department. And therefore, now why didn't you take that stand then?
No, admissible amount was, my lord, I said it is the admissible amount.
Understood. But why didn't you take a stand that it is the health department?
That probably was not.
Now a stand is now being adopted by the PWD to that effect.
Well, let them submit a proposal, at least I can pursue with the health department, because there is the order otherwise. And proposal will have to go.
No, then why the PWD is not working out with the health
they will have
department?
to-
Because you have taken up that issue for the health department. So let the PWD take up the issue
Yes,
with the
yes,
health
Lordship will
department
record
and
it.
ask the health department to
Yes,
submit the
for
proposal so that the thing can be worked out.
I will intimate, my lord, to the. health
This
sec-
needs to be correct because you see, if these are types later on, these aspect comes in because the deponent, here the affidavit which has been filed is the deponent begs to state that one fresh demand was submitted by the superintendent in month for release of so and so, which was returned back for resubmission after attending the observation. They begs to say the said demand has now been resubmitted after satisfying the points. So these were never being taken as regards the health department.
No, my lord,
business.
one more thing, my lord.
Hmm.
The order, final order says, in view of the aforesaid facts and circumstances, this court is of the opinion that this writ petition, which is pending since so and so, is disposed of with a direction within a.
No, because this is the second round of litigation which came in. You see the first paragraph,
Lordship
second
has not said, my lord, it is the PWD will have to pay.
Huh.
They may implement the health departments if that particular instruction has been furnished today by the PWD that because of non-allotting the fund, PWD has not been able to make the payment. They can make the, my lord, health department a party.
That is not in a contempt. How can they make? Because in the writ petition, they are not there.
No, they can, my lord, give a notice to the health department also, my lord. It's not required, my lord. So if somebody creates any hindrance in, my lord, complying with the court's order, automatically it will be under contempt. Immaterial, my lord, because these are technical issues, my lord, between the department. Or Lordship will, my lord, give me some time, I will have the instruction, my lord, regarding the
Obtain that
proposal.
instruction because you are appearing for the health also, na? You take up the issue because you see that it doesn't show in good light.
Lordship.
Mr. B. Gogoi, the learned additional advocate general, who is also the standing counsel of the Public Works Department as well as the Health Department of the Government of Assam, submits that he will obtain instructions as to why the order dated 8/3/2021 passed in WPC number 343/2015 have not yet been complied with.
The court has no instruction to give.
Full stop. It is pertinent, however, to mention that though while disposing of the writ petition being WPC number 343/2015, there was no stand taken by the PWD department that the amount has to be defrayed by the health department. However, in the affidavit so filed by the respondent number 1 in the instant proceedings, it is seen that the said work order pertains to was issued by the PWD department at the instance of the Health and Family Welfare Department. So under such circumstances, this court therefore directs the directs the Mr. B. Gogoi therefore shall apprise this court as regards the query so made herein above on the next date. List this matter on 23rd of February 2022, 26.
Probably, my lord, this proposal, my lord, is of 2021. PW will have to submit a fresh proposal. That has left, my lord, 2021 proposal.
Something has to be done because you see, the
Ultimately,
problem arises because that stand was not taken by you also. If a stand was taken also, he could have amended. Just I'm having the same problem which that writ petition, those writ petitions of the water resource departments, where there were certain directions being issued to the water resource department to make payment. Later on, they come up and say that you see, Ministry of Jal Shakti is not there. Now, Ministry of Jal Shakti thereupon was directed, and in some cases, directions were passed to make the payment. Now, the directions were such. Now, the water resource is filing review after review saying that, look here, Ministry of Jal Shakti is not paying, so there are a lot of contempt matters. So the only way is that then the review order I have passed, and I think the coordinate bench has said that if they don't make the Ministry of Jal Shakti, the contempt has to be dropped. So that is what is happening.
They may implement melody. Lord Civil examine.
No, here I can't. Let us first get your instruction.
Yes, yes.
Then we'll take it up on the next date if there is a necessary, because that would, as you said rightly, it would amount to interference with the orders passed by this court. So we'll pass an order to that effect later on. First, let us get the year, because you see the affidavit which has been filed by the respondent number 1, there are certain enclosures given out there to the effect that it is being forwarded to the health department. The health department is not taking up. So I think if you can, if further orders are required, we'll take good.
My lord, as per the last order, 10/12/2025, my lord, an amount has been deposited, my lord. Previously, my lord, an amount of 10 lakhs, my lord, a check with regard to from treasury, but it was not accepted in the registry. And this was informed to the review court also, my lord, and the review was dismissed, my lord. So as for the 10/12 order, my lord, this money has already been deposited in his account, my lord. That appears in the annexure itself, my lord. Jan Mohammed Talukdar. After statutory deductions and all.
So you have paid the money 10 lakhs.
10 lakhs through treasury directly to his account. That second document should say so.
Okay. You have received.
9 lakh 30,000, 9 lakh 30,000.
Yes.
That is doubled in the account. Out of that, we deducted for picture. So remaining amount of 12,60,000 still remember.
How much, what is the direction passed?
Direction was with regard to,
Direction for.
was for.
27 lakhs 60,000,
Yes,
out of which 10 lakhs you have paid.
yes.
Remaining,
5 lakhs earlier,
15 lakhs.
15 lakhs it already been paid, my.
1260 remains.
Yes.
When are you paying?
May I pray for at least, my lord, the next financial starting will clear it, my lord.
April?
April, my lord. If it is possible, my lord.
No. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. A.K. Bhuya, the learned senior standing counsel of the PTC. Full stop. The instant writ petition has been filed. Instant contempt application has been filed alleging willful and deliberate violation to the order passed by this court dated 10/4/2023 in WPC number 1/888/2023. Whereby this court had directed the respondents to pay an amount of rupees 27,60,000 within a period of 3 months. Full stop. It is seen that pursuant to certain orders being passed by this court, the BTC authorities have already cleared 15 lakhs and have already paid to the petitioner an amount of rupees 15 lakhs. Full stop. Mr. A.K. Bhuya, the learned senior standing counsel of the BTC, submits that the remaining amount of rupees 12,60,000 would be paid in the beginning of the next financial year.
My lord.
Taking into account the above, list this matter on 4th of May 2026.
Deeply obliged.
In the meantime, the respondents shall take every steps so that the amount is, the remaining amount of rupees 12,60,000 is paid to the petitioner. Full stop. List the matter for an update.
Deeply obliged.
Yes. Lordship, this case, Lordship, I would like to take your Lordship to the court's or High Court's order, Lordship, at page 13. Which directs to verify the pending material bills. And if any, if upon verification, if it is found any outstanding amount that should be paid.
What is the affidavit filed?
Lordship, the respondent number 1, Lordship, there are 2 sets of bills, Lordship. One they says not permissible work, Lordship. That's Lordship. Apart from that, the other work, Lordship, they have not disputed the admitted amount. And also on last 23rd.
Where is the directions passed by this court?
Lordship, page 11.
It's found that the petitioner is entitled to some outstanding amount. The admitted liability should be paid entire accessible within 2 months. Okay. Who is paying for the respondent? PNRD.
For the department, my lord.
Yes, what is your stand?
Our stand, my lord, the admitted amount, my lord, we have already paid, man.
Paid. Yes. Then?
From
Where
my
is the
side,
verification?
my lord.
Where
My
is the
lord,
verification?
the district commissioner, I think, my lord, they had filed a affidavit, my lord.
Who?
Respondent number 3 is the BDO, Lordship.
Respondent number 1.
Respondent number the commissioner.
Where?
Contempt.
Respondent number 3 in affidavit, Lordship, they have said, Lordship, they have done physical verification after 4 years of completion of the.
Page
work.
105, page 105, my lord.
And now they have said, Lordship, admitted amount is 9,54,000.
9,51,000. You have paid that?
Wait.
That also not paid,
It
only
is-
7 lakh, 7 lakh something paid, Lordship.
You have got some amount except 1,61,000. That you have not received. Remaining you have received.
So we paise,
That is, as per their Lordship, my admitted amount is 25 lakh.
You can.
Very well, no problem.
Yes, out of this 9 lakh lordship, only.
As per them, it is 9 lakhs. So the court has passed an order that there will be a verification and their outstanding will be paid within 2 months. Out of that, they have verified and found out that the amount is 9 lakhs 54,687, out of which certain amounts have been paid minus 1,61,521.
That's so probably by now he has received because
You filed the affidavit when?
my lord, on
212.
2nd of December.
2nd of, now they have paid.
My lord, because it was because payment is due to technical problem, the same will be solved within a week. That is my lord, already from
Page
date of-
106, madam.
Already that has gone, my lord.
That
So
has
due
not
to
been
some
paid also.
technical problem,
Okay. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. Udas appears on behalf of some respondents and Mr. S. Dutta also appears for some of the respondents. The present contempt application is filed alleging willful and deliberate violation to the order dated 28/2/2024 passed in WPC number 1042/2024 that whereby there was a direction to carry out the verification, and if it is found that the petitioner is entitled to some outstanding amount, the admitted liability should be paid by the petitioner respondents. Full stop. It is the case of the petitioner that the petitioner is actually entitled to an amount of rupees 28,26,895. However, upon verification, the respondents have found that the total amount payable to the petitioner in respect to the various works is 9,54,687. It is stated by Ms. Udas that as per her verbal instructions, the remaining the entire amount has been paid. However, she would produce the instructions, written instructions on the next date as to whether the entire amount has been duly paid. Full stop. The counsel appearing on behalf of the petitioner, however, submitted that the verification has not been properly done.
No, lordship, here verification is verification of the bills, lordship. They have done physical, there's no direction for physical verification.
Verification of the bills have not been properly done.
No.
That is your contention
My-
of the. Full stop. It is the opinion of this court that if the petitioner is aggrieved with the verification, the recourse available to the petitioner in respect to the remaining amount is by way of a civil suit. Accordingly, keeping the instant proceedings pending for instructions as to whether the entire amount of rupees 9,54,647 has been paid or not, this court grants liberty to the petitioner to file civil suit against the respondents as regards the remaining amount and the period from the filing of WPC number 1042/2024 till date be excluded while computing the period of limitation.
Lordship, the phone number, the admitted, lordship, bills or.
Problem is that, you see, the order is you verify. Now they verify and come up with this amount. You need some more amount, go to the civil court. Remaining, this I'm keeping it pending. List this matter again on 19th of January 2026 for an update.
Hello, please.
Yes, you wanted upgrading, why? You thought that this court won't reach the,
Part of the last case, 8/12/2025. So. My lord,
yes, what is this?
my lord, the order.
Where's the order?
Order, my lord, start from page 19, the operative part is at page 22. Direction was given to verify and example of the page in terms of.
Okay. Now, what is your allegation?
My lord, I have been given part payment, out of 45 lakhs was released, then 21 was the balance amount for which I have filed the requisition. And in writ petition, my lord, no affidavit was filed on the part of the respondents, and the court ultimately decided by passing this order and directing them.
What is your allegation?
Currently, my lord, yes, currently, my lord, after obtaining this certified copy, I have furnished the copy before the concerned authority, that is, my lord, the chief engineer. And then, my lord, to comply with the order, I have forwarded with it, they have received it. Then again, my lord, after a few months, my lord, as they did not comply, again, I have filed another representation.
What is your allegation?
That they are not complying, my lord.
Compliance of what?
Compliance of the part of.
Is it your case that verification has not been
Yes,
done?
my lord.
Or payment has not been made?
No status or report has been given to me. I am not even in a position to know, my lord, what is the status of my verification till date, my lord.
Okay.
And no amount has been released yet, my lord.
No, amount will be released only as per Tamsir Ali, chronological list.
And I'm basically here because, my lord, they should at least give me the status of what they have done with the order and the directions, my lord, to know, my lord, whether they have actually acted upon the order or not, my lord. And notice was issued, and my lord, I have informed my learned friend who is appearing for PhD department. He was here, in fact, maybe he must be.
Where is the counsel from PhD department?
I was told he was in Eggs, he's currently on Eggs, Mr. E. Gogoi. I informed him, he's on Eggs.
I'll inform him in option that.
Find out why, you see, the problem arises is that order. PhD department does not maintain a chronological list. Problem arises there. Tamsir Ali cannot apply it there because it is only the PWD who has done it. And now BTC is following the suit. But the fact remains that how is it possible if this direction is being passed? Very difficult. Find out what has happened as to regards whether the verification has been carried out.
Very good.
Can you find it out?
If your lordship has the matter after.
Oh, yes, ask anybody of them to come.
Very well.
Because otherwise they have, notice has been issued and the service is complete or what?
No, my lord, it's still awaited, my lord.
So then,
No, my lord, today it has come out, the application. my lord,
why do you want to upgrade?
On the basis of the order.
My goodness,
The application, my lord.
service not complete. The council appearing on behalf of the petitioner is directed to take fresh steps
steps,
upon the respondents.
I'm obliged, my lord.
Oh, my goodness.
No, my lord.
I thought something was serious on this.
Anyway, I'm obliged, my lord.
Next time I will take it with a pinch of salt when you ask for upgrading. Ah,
I'm obliged.
yes, what is this?
My lord, in the rate petitions, my lord, item 29 and 30 are similar. Rate petitions were disposed of, my lord, by directing the respondent authorities to pay the outstanding bill amount in terms of, my lord, Tamsir Ali. Now, my lord, so far as the first petition is concerned, my lord, Mihir Deka, that is item 29, which is before your lordship, there the amount is 55 lakhs. And the second contempt case, my lord, that is the second writ petition, that is 76 lakhs. Now, in the instructions, lordship will kindly see, my lord, the second page of the instructions. The budget allotment has already been made. Now, so far as, my lord, Mihir Deka is concerned,
You are Mr. A. Patel? You are to comply, you first submit your GST registration. We take it after some time, some other day. In all the instructions must be same.
my lord, that instruction pertains to both the contempt cases. Two contempt cases are there, 29 and 30.
Okay, 29, he is not GST compliant in both.
No, my lord, so far as 29 is concerned, GST compliance is there. With regard to, my lord, that writ petitioner, that is Mihir Deka, my lord, the amount will be released shortly, my lord. The ceiling proposal will be submitted and the financial sanction will be done.
You make 2 copies, 1 more copy, huh?
My lord,
Give it to this court. Into court.
lordship may retain this, my lord.
Mihideka, we are taking up first is Mihideka.
Mihideka is already there.
Mr. Arbor Pujari, the learned counsel appearing on behalf of the Revenue and
Respondent one,
Disaster
my lord.
Management Department of the Government of Assam submits,
I am appearing as respondent one, my lord.
appearing on behalf of the respondent number one, submits that insofar as the financial sanction to the tune of rupees 55.84040 lakhs
Yes, ma'am.
have already been initiated insofar as the petitioner is concerned, and after that, the sealing proposal shall be submitted to the Finance Department for final release of the funds. In that regard, he has placed an instruction dated 17/12/2025, which is kept on record and marked with the letter Y. Full stop. Taking into account the above, list this matter again on 3rd of March,
Yes.
2nd of March, 2026.
My lord.
In the meantime, the respondents herein are directed to take effective steps so that the amount to which the petitioner has been held to be entitled, that is rupees 55,84,040, be released to the petitioner. ইখনত লিখিব ভৱনাথ কণ্ঠনাথ পুস্তক
It is second of March.
on X.
Second.
Mr. Arbor Pujari appearing on behalf of the petitioner, on behalf of the respondent number one, submits that insofar as the petitioner in concern, the financial sanction could not be initiated in as much as the petitioner is not a GST compliant.
Yes.
He therefore submitted that the petitioner should ensure GST compliance before is required to carry out the GST compliance. The said instruction is kept on record and marked with the letter X. Mr. A. Pator, appearing on behalf of the petitioner, submits that the petitioner will duly take necessary steps in that regard and submit the GST compliance certificate before the respondent number,
District Commission, two.
before the
Respondent,
respondent number two.
Two.
Full stop. This matter again on 2nd of March for an update as to what is as regards the stage of the financial proposal.
I am obliged.
What is this?
Petitioner had participated in a selection procedure by IOCL for settlement of a retail outlet development. Was selected in the group one category. He was selected in the group one category. There, the requirement is that if he's entered into a lease deed, that lease deed has to be executed with all the co-owners. Now, in this case, there were three owners, three people whose names were reflected in the patta. The IOCL has demanded for a NOC, not only from the third person whose name is reflected in the patta, but also from the next of kin of that person, holding them to be co-owners. When the patta by itself, there had been a family partition amongst those two persons, and now their names have been mutated also. Presently, my limited prayer before Lordship is the document which I had submitted. That document is a lease deed which is executed with all the co-owners of the property. And that should be considered by the IOCL, Your Lordship. Now I've been relegated to group three. Your Lordship.
Where is that communication?
Where's the
Where is first your lease deed?
The lease deed, Your Lordship, will find at page number, it starts at 36 and the relevant portion is at 37.
So and so. They are the two.
They are the two.
Borindra Sutradhar,
And Bokhanto Sutradhar.
Bokhanta Sutradhar.
And this,
With Zaki Rabha.
I am Jacqueline,
Lease for a period of
23 years.
Where is the year? There is another Bornali Sutradhar. Who is this?
Your lordship, there has been a family partition.
Ah,
Bornali Sutradhar is the wife of the deceased brothers of the other two deceased.
then
Deceased. Her name, your lordship, there had been a family partition and she had given an affidavit to that effect. That there has been a partition and she is occupying her share of the property. That property has not been leased out to him. Now there has been a mutation and her name has also been removed from the patta.
new patta.
Yes, there is a the patta, your lordship, the chitha, the correction has been made.
Where?
That your lordship will find the page number 53.
50?
53.
Name has been removed.
Yes. In fact, I had got a affidavit, an NOC on affidavit from this person.
Now where is the rejection?
Section, your lordship will find that page number 54 here.
Huh?
54.
Is the data area was executed between the selected so and two owners, namely so and so of the total of demand, so and so in according endeavor, the third owner, so as per so demand, the occurred and the long. Yes. Okay. Yes, Mr. Borua.
Yes, my lord, this was the previous Jama Bandi, the deceased brother.
No, I think you, this needs to be interfered with. Taking into account, yes, the lease disease people,
Yes.
and thereupon there has been a sitter. This is a revenue record. Now, revenue record categorically says, I don't think you should have a problem now.
Now I think that possibly, yes, we have to consider his document afresh.
That I think you should need it.
Yes, that.
So I think we will issue notice and a stay being granted to this, directing you to reconsider pending the notice.
Pending the notice.
I think this is a better, because
Giving-
you see, initially when the particular contract was entered into, the lease deed was entered into, the lease deed was in respect of 1 bigha of land. Then this particular patta had 2 bighas, 13 lectures.
Yes.
Then the recent patta, which is being issued now, it categorically shows that it has 1 bigha, 2 katha, 2 lectures. So therefore, and it is absolutely in their name. So that document was very much there. So I think it's a case you may reconsider in the meantime, and reconsider, then you can act fast. If you don't, we will one day set aside your decision. Issue notice making it returnable on where you're making all the other people a party.
This is actually the second round of litigation, lordship. When the previous petition was moved, the coordinate bench was of the opinion that the other bidders in the group 2 and group 3, they are necessary parties. So we withdrew that petition and we have filed it, of course.
See? You create a big problem there. What to do? Because you don't, the question is, here is whether you can come under group 1.
Yes, sir. They are in group 2 and 3.
At best, the parties could have been the other group 1s.
Yes, yes.
Yes, sir.
Because what happens, he is relegated to group 3. But as regards the other group 1, you will again have a lottery.
Yes, these are the group 1 only. These are the persons who are group 1.
My instructions are that these are the other group 2 and group.
Can't be so. I don't think
these
so.
are group 1.
This will be
remember
group 1.
these are group
That might
ones.
be the reason why.
Yes, there's a confusion there. These are group 1.
Issue notice making it returnable on how much time for you to rethink?
Madam, may I have it immediately after the Bihu vacation? There is a
11th of February?
11th February.
11th of February, 2025, 26. Mr. N. Bulwa accepts notice on behalf of the respondent number 1 and 2. No government? Oh, your government? You accept notice? Okay, Mr. K. Gogoi. Mr. K. Gogoi accepts notice on behalf of the respondent number 3. Extra copies of the writ petition be served upon this council by tomorrow. As regards the respondent number 4, 5, 6, and 7, the petitioner is directed to take steps by tomorrow through speed post. Further to that, the petitioner is also given the liberty, I'm doing a stay, directed to also effect service upon the respondents. Why they all have the same address?
Because I do not know, have their full addresses, I have mentioned parties to the ICL authority.
They can serve upon us. Okay, I think they can serve upon us.
Okay. As regards the respondent, as regards the respondent number 4 to the speed post knowledge. As regards the respondent number 4 to 7, this court taking into account that the address has been made care of, the respondent, the manager retail sales IOCL Guwahati. This court directs the petitioner to effect service, serve extra copies of the writ petitions. As regards the respondent numbers 4 to 7 upon Mr. N. Bulwa, who represents the respondent number 1 and 2, so that service can be meted out upon the respondent numbers 4 to 7 through the manager retail sales IOCL. The grievance of the petitioner herein is that the petitioner has been relegated to Group 3 by the communication dated 17/7/2025. Why are you approaching now?
This is the second petition. I had filed a petition earlier, I had to withdraw that. The order, your lordship, is also no.
It is the case of the petitioner that it is the case of the petitioner that pursuant to where the retail advertisement?
The advertisement, your lordship, is not on record. My form is there. Your lordship.
Huh?
My application form is there.
Where is your advertisement?
The advertisement is not on record.
Poorly drafted. In pursuance to an advertisement issued where?
28 June 2023. 28 June 2023.
20 June 2023 in the News Daily. Which one?
My lord, this is not in the News Daily, this is on the portal
In the portal
of the
of the respondent number 1. The petitioner applied (28/6/2023). The petitioner applied for allotment of a retail outlet where?
On the application is there 22, page number 20.
Where area?
Gwalpara.
What Gwalpara?
In Gwalpara, the area, your lordship, will find a page number 23.
In the location between Solmara Junction and Ajiag bus stop on 37 old / NH 17 new on the left hand side towards Naranarayan Hetu. The petitioner submitted his application on 17/10/2023 claiming itself to belong to the Group 1 category on the basis of a registered lease deed entered into by and between the petitioner and one Borindra Sutradhar and Sri Bosanta Sutradhar. The said registered lease deed dated 16/10/2023 have been enclosed as Annexure 6 to the writ petition. A perusal of the said lease deed reveals that the lease was taken for a plot of land at measuring 1 biga, which is covered by Dag number 90 pertaining to Patta number 13 in Revenue Village Budhipara under Balijana Revenue Circle, District Walpara. Full stop. It is also pertinent to take note of that prior to the execution and registration of the said lease deed, comma, the petitioner as well as his lessors have obtained necessary NOC in terms with Section 21A of the Registration Act 1908 insofar as the same is applicable to the state of Assam. In the draw of lots, which was held amongst the Group 1 category candidates, comma, the petitioner was found to be, the petitioner was provisionally selected. Full stop. However, by the impugned communication dated 17/7/2025, the said candidature of the petitioner insofar as the Group 1 category candidate was rejected and the petitioner was relegated to the Group 3 category. Mr. K.P. Pathak, the learned counsel appearing on behalf of the petitioner, submitted that at the time when the lease deed was executed by and between the petitioner as well as his lessors, the lessors were co-owners of a plot of land at measuring 2 biga 13 lessors. Pursuant to it too, there was a partition which was at that relevant point of time, comma, when the lease deed was executed, there was already a family partition. However, pursuant thereto, upon partition being sought for before the revenue authorities have already partitioned the said land. On the basis of an order dated 10/4/2025, prior to the impugned communication dated 17/7/2025. In that regard, reference was made to Annexure 11 of the writ petition, wherewith a new record of rights have been prepared in respect to the land which was land leased out by the lessors to the petitioner. The learned counsel therefore submitted that the respondent authorities ought to have taken into consideration of the said aspect prior to issuance of the impugned communication, more so when the lease deed was executed prior to the submission of the application form. Full stop. Mr. N. Bulwa, the learned counsel appearing on behalf of the respondent number 1 and 2, submits that he would obtain instructions. He further submitted that it is required to be looked into on the basis of the terms and conditions of the brochure as to whether subsequent partition, if there is a subsequent partition, comma, which is recorded in the if there is a if the record of rights are corrected subsequent to, whether the respondents are in a position to take into consideration the same. Full stop. This court have given an anxious consideration as regards the respective submissions, and it is the prima facie opinion of this court that as the lease deed was executed prior to submission of the bid of the application form, and further to that, the permission was also accorded. The NOCs was also being issued by the respondent number 3 prior to issuance of the lease deed, prior to execution and registration of the lease deed, and the subsequent correction of the records. The petitioner have been able to make out a case for passing of interim directions till the next date. Accordingly, the interim directions. Accordingly, this court passes the following interim directions. Number 1, the respondent authorities shall not further proceed with the notice, the communication. This court, the respondent authority, the impugned communication dated, where is that page 50? The impugned communication dated 17. Page?
Page 54.
54. The impugned communication dated 17/7/2024-25, issued by the head of the divisional office, Guwahati Divisional Office, Indian Oil Corporation, to the petitioner is stayed. Number 2, the respondent authorities are at liberty, pending the notice, to reconsider as to whether to reconsider its decision, to reconsider the case of the petitioner in view of the correction of the record of rights and the partition, thereby giving the lessors of the petitioner clear right to lease in respect to the land in question. First, list according. What is this so big file?
RFP is big, that is why it's big, otherwise relevant documents are big. But in purpose of a notice inviting tender, petitioner submitted a tender, it became L1. Ultimately, it was NR.
Huh?
Without giving any reasons.
Which is the department?
MOT, government.
MOT is by,
The notice is at page 35 for construction of road in the highway. Madam.
why are you filing it here?
Because my lord, page 87, not to kindly say, otherwise they have got a regional office here. Plus page 87, they say they.
So what? Who has issued the notice inviting tender?
Well, the code there, then in the RFP it is mentioned, court in Guwahati only we have it.
Where?
Page 87. Ma'am. (6.1) The bidding process shall be governed by and constituted in accordance with the laws of India, and the courts at Guwahati shall have exclusive jurisdiction over all disputes arising under pursuant to in connection with the bidding.
Okay, now what is your, where is the other side?
Other Union of India will serve notice.
Huh? Quashing the corrigendum number 4 dated 8/12 issued by Mott. Issue a reader directing the respondent authorities to award the work order to the JV, which is a L1 bidder.
Madam, we are.
Who is JV?
JV is the, there are two companies, they have jointly participated in the process.
JV is not a party.
In the repeat manner,
Huh?
one of the parties has been authorized by the JV to file this.
One of the parties have been authorized by the JV.
JV,
Is JV and not a juristic entity?
the documents say that the final constitution of the JV is yet to take place.
Then the other party has to come.
Number, other party has issued NOC and authorized the one party to come. That is why we are filing.
How can I direct? I have an order passed. Pass the direction, not possible. Not possible.
Before is the authority letter.
Page
34. Due to Mr. Satish Agarwal and company for filing and pursuing the petition because of the Guwahati High Court. We, Mr. Neeraj Siman Structures Limited, having its registered office at Spencer and so. Do hereby authorize and empower Mr. Satish Agarwal and company in partnership farm, having its registered office at Spencer, to file, institute, and sign, etc. in Guwahati High Court. And continue with the proceedings.
You have authorized him. They have authorized you to file a case.
Right. Both
Regarding what?
the next paragraph. The
Ah.
authorization is granted in relation to the matter concerning joint bidding agreement entered on so amongst so of jointly participating in the bidding process for the project request for proposal number so in the present RFP.
So what is the power given? Pursuant to this authorization shall be entitled to engage,
Yes.
appoint, instruct advocates, counsels. For whom? Them. Sign, affirm, pleadings, affidavits, wakalatnama, joint judge, application for them. Appear, act, do all necessary acts and things as may be necessary or incidental for effective prosecution of the said writ petition. Represent so and so. Our interest before any department, authority or tribunal in connection to the said proceedings. So are they not required to be a party then? It can be filed on through them, but don't you think they have to be made a party?
Otherwise, both of them should have come. In fact, the JV itself could have come. We were thinking. that
Normally, the JV should have.
JV,
JV along with the other two partners, normally, has to come.
yes.
Because tomorrow JV is the entity.
Ultimately, JV is the entity.
Because
But
if you see
is
JV.
fully constituted, then it becomes a
Yes.
entity. But for
So
the
JV is the entity. Otherwise,
Right.
okay, two partners of the JV can very well come and say that for JV. Normally, in view of that judgment, there's one judgment wherein says that JV is a juristic entity.
Yes, ma'am.
If it is a juristic entity, if
It
it
can
is a cancellation, and more
Yeah.
particularly you are asking for a writ that the JV should be getting it. There is one judgment passed by me. I forgot the name. Exactly on this point. I've said no, repetition is not maintainable.
by one of the.
Matter went to the division bench also affirmed it. Matter went to Supreme Court also affirmed. So I'm bound. So you do one thing,
Madam,
you file an application today, but tomorrow, we have it tomorrow as an I, and then we implead and then proceed. Because you have been authorized.
we'll file tomorrow morning.
That day, one Mr. Ash Sharma, he also had that problem. I corrected it, got it corrected, and then case has also been successful now.
We'll file an application to implement the JV
JV. No, JV and this
and
person,
other entity.
make it 3. And it's also mentioned out there that the petitioner be read as petitioners. List the matter tomorrow at 2 p.m. for motion. In the meantime, you do that.
Madam,
And why no central government is appearing?
we'll ensure tomorrow, and today we inform again.
So list the matter tomorrow at 2 p.m. The central, the registry shall. Whom have you served a copy?
My lord, the council for the NHIPCL, they are not appearing, so it will be RKD Chaudhary, Madam, central government, and RKD Chaudhary. We'll serve-
Mort is
Mort
who?
The Government of India, Union of India.
Showing the name of Mr. R.K. Dev Chaudhary, DY SGI.
Okay.
All the certain clauses of a tender is under challenge in this petition, which might have debarred the petitioner from participating in the matter. In the tender process. Your lordship kindly comes to my lord, page 39, that is the my lord bid document.
Yes.
This has been issued on 4th of December 2025. And
Bid opening is tomorrow.
so today, my lord.
Oh, today, the 18th.
Now,
You have submitted the bid.
My lord.
You have submitted the bid.
My lord, the bid has not been accepted because, my lord, I do not fulfill the criteria of having, my lord, the trade license in the state of Assam for a period of 7 months.
Oh, you don't have a trade license.
I'm West Bengal, my lord. This farm is from West Bengal. I have a trade license in West Bengal, my lord, not in Assam. And my lord, that requirement has no nexus with the purpose of to be achieved in this, my lord.
Where is that condition?
My lord, your lordship would find mine at page 39 inside, my lord. There are 2 criteria, but then your lordship may turn to page 44, my lord. Page 44 says, my lord, clause 10, buyer added with specific ATC, additional terms and conditions. Then your lordship may kindly come to clause 12, buyer added with specific ATC. My lord, a brief has been stated here. Buyer added text based ATC clauses, number 1. Accredited bidder service provider should have local office in the state of Assam for the last 7 years with valid trade license. Then, my lord, the actual clause, my lord, then we have to click there, my lord. Then we get that ATC that your lordship finds at page 47. Those clauses will be relevant, my lord.
Yes.
Now, clause C is, my lord, statutory registration. The bidder must possess valid PAN-based registration. So then, my lord, note clause, the bidder must possess GST registration and trade license.
Where? Page?
My lord, page 47, clause C, I am reading.
C, huh?
C. The bidder must possess valid PAN, GST registration, FSSAI, food safety certificate and trade license and all other statutory registration required under the relevant laws. This I fulfill this part, my lord. The bidder must possess GST registration and trade license registered in the state of Assam for the last 7 years. And my lord, the clause D will also be relevant, my lord. Office location, the bidder must have a functional local office in Assam or provide proof of readiness to establish a local operational base at the Silchar Medical College and Hospital if awarded the.
But this can be taken care of
That
later.
can be taken care of, but this clause, my lord, this has debarred me from participating. And my lord, although the notification was of my lord 4th of December, today is the last date, but they, my lord, they'll only open the, my lord, the technical bid. And in technical bid, my lord, there is nothing secret about the technical bid. Perhaps, my lord, still I have got some hope if your worship permits that, my lord, my bid should be accepted and evaluated at least on the, my lord, technical side.
This is for kitchen service. For which year? Period?
Period is for 2 years. Page 39, your worship will find that the contract period is for a period of 2 years.
Mr. Mehta Gogoi, period will start from when?
My lord, it will be from the date of, my lord, issuing the order. Otherwise, my lord, whoever is continuing, he will continue, my lord. Whoever is continuing supplying as on date, he will continue, my lord. Prior to, my lord, expiry of the, my lord, present, my lord, lease or bid, my lord, tenure, my lord, this tender process is initiated. Probably, my lord.
Because you see, why I'm saying so, GST registration, he can very well get it. There's no problem in that. Because you see, there might be a GST registration pan India also, but there may be a GST registration which is
Limited to
in
the
respect to the state. That is permissible.
My lord.
Now, the second is having a trade license registered in the state of Assam for the last 7 years.
My lord.
Meaning it can be only from Assam.
Only for Assam.
You don't want outside.
Yes.
But why you are having then that proof of readiness to establish a local operational base at Silchar? If awarded the contract, how do you means is it the thing that you are having or going to have they
No.
are settled here,
No, my lord, they will have to say.
must
settle
have
it, my
a
lord.
you say the bidder must have a functional local office in Assam
Hmm.
or provide proof of readiness to establish a local functional base
Basis, Silchar.
at Silchar Medical College and Hospital if awarded the contract. Here it is not end,
Or,
which makes it a very confusing. Means on one hand, you are saying either you have an office in Assam
yes, my lord.
or you have this, which means he can very well comply later on.
If, that's why if award
So
the
he can
contract.
comply
that's not-
later on.
No.
So it takes away that he needs to have an office.
Yes, my lord. Only if it is awarded, he will have to show that.
That's okay. But it takes away that he needs to have an office. If he is awarded, he can still open
Yes.
his readiness. Then if that be so, why do you need the registration in Assam of a trade license? He can obtain a trade license also.
No, my lord, these are the preconditions, my lord.
No, understood, but trade conditions is there.
Because after, my lord, awarding the contract, if he starts, my lord, applies for trade license, somehow it's not given, again we'll be in trouble. So that's a requirement. They thought that it should be there. And this particular clause is there in every, my lord, tender issued by the medical colleges of various medical of the state for this particular purpose. It's a common format. That's what I have talked with them. They said this is the format. And if at all, Lordship will kindly see, my lord, if at all this particular provision is to be relaxed, then it will have to be, my lord, relaxed for all. Then there will be more participant, my lord, if at all, my lord. Some cannot be limited to the petitioner.
Well, I have stated in my petition that my lord, in all India Institute of Medical Science and other medical colleges, my lord, this condition is not there, my lord.
Where?
In paragraph 14, I have stated, my lord. And in fact, the petitioner is serving, my lord, who taking contract in other states, 2 other states also besides West Bengal. Paragraph 14 at page 9.
Where are those documents?
My lord,
Where are those documents?
documents I have not submitted, but I have many statements on oath, my lord. Those documents I can produce.
One more thing I would like to point out, my lord, page 42, there was a provision for pre-bid meeting. The petitioner never brought the authorities in the pre-bid meeting. He should have clarified, my lord, on this point. You should have raised the objection at that point of time at page 42, at the top. Pre-bid details. It was on 6/12/2025. It was held. Two bidders, my lord, they raised certain queries. That was clarified. Pre-bid date and time, 6/12/2025. Office of the Superintendent, systematic.
Where is the page 40?
Page 42 at the top.
42. In fact, my lord, NIP visit, my lord, court. And this is fixed on 6th.
Huh? Pre-bid, bid venue 6/12. The bid was issued on 4/12. You can go on 6/12. Because it is to be submitted by 18/12.
18/12, yes.
And you should have approached earlier. You saw it yesterday.
In fact, my lord, no, they have tried, my lord. They thought that it will be accepted with that effect and they were trying, my lord, till the other day. They could not, my lord, even yesterday they could not, my lord. The system is not accepted.
I don't allow permission to submit subject to
Hard copy.
consideration. That creates another big issue problem.
In fact, my lord, at 11, my lord, the portal gets closed. It's an online, my lord, bid. That portal is closed for submission of bid.
The period is also over.
Then it will be, my lord, difficult. My lord, we cannot, we'll have
No,
to.
no, otherwise also, where is 11?
My lord, page 39.
11:30.
Yes. No, 11:30 is the time for opening the bid. 11 is the time, my lord, by which it will have to be uploaded.
So it is closed.
Portal
This is
gets
in the
closed.
Assam portal.
Jam.
Them.
Huh? Or JAM.
Jam.
Very difficult.
The portal did not accept because of the fact Assam GSTN is not there. Assam GSTN.
Did you submit?
We wanted to, my lord, the portal did not accept that.
Oh.
Even yesterday, my lord, he didn't, my lord, last time also, my lord, they tried. As they are asking for GSTN of Assam. That's why, my lord, the portal.
You could have got the GST from Assam. What was the problem? You could have applied, they would have given it. If you were interested. They want to localize it.
My lord, whether that can be done, my lord, what is, whether, my lord, that is permissible, my lord, that you restrict it only to the state of Assam and, my lord, debarring other participants.
This is where Silchar Medical.
Medical College.
Perhaps your worship may direct, my lord, that physical copy will be, my lord, accepted and they can,
That too, I will never do it. That is impossible, Mr. Chaudhary. I'm only thinking is, can I keep this matter pending only? So that in future we can consider this aspect. But here you have lost the bus.
my lord, the issue remains, my lord, whether that participation can be, debarred. Whether such participation in a tender process can be debarred, my lord, localized and, my lord, all.
You consider, that is why I'm thinking that for future we can think about that it cannot be as an academic issue in a cooler brain. But otherwise you don't have, I'm not going to pass an interim now.
Till now, my lord, no.
And without an interim, your petition becomes infructuous.
And, my lord, no third party right has been created as such still today.
No, you cannot submit. You see, as of now, you cannot submit. And if I only allow you to submit by way of a physical, which I cannot because it's a GEM portal.
Yes.
GEM portal physical, you cannot submit. Not possible. Bid opening has also taken place.
That is so far as, my lord, the technical view is concerned.
Bid opening is also at 11:30.
Yes.
11:30.
By the time it has now been cancelled also.
Maybe. If
Uh,
there is
then
no
also-
bidder, my lord, probably it will be cancelled. If there is no bidder in that case, it will be cancelled, my lord. Of competition.
And if it is a you just hope and expect, we keep this matter pending, hope and expect. Then if there is only single bidder, then they may go for press.
My lord, I am before your worship, my lord, taking this reverse. That,
Mr. Chaudhary, taking up bench for all these whiles, I've seen the problem which it is created by allowing consideration subject to final and next outcome. It becomes a huge problem. I won't say there's one matter that this is the problem. And every time I'm faced with that, and this has that order has led to three other writ petitions, writ appeals, all these things because of that single order, where he did not qualify, but the court said, okay, consider his case without that. And now they have considered and said, look here, we are not going to give you without that. Then the second round. Again, then another writ appeal has been filed.
So, one of the primary issues whether, my lord, they can debar the other participant.
That is a question of academic interest now. Whether it can be debarred or not, it's an academic interest. There is a four days period given in GEM, na? After the tender is over, means is it only given to those people
No, that
who
will
have
be
participated?
Only for those, when they can change something and all, some period is given. Where, my lord, we can
That a
also.
person who could not submit also,
No.
because of the GST or trade license not being there, can he approach within the 4 days?
No, my lord. After the last
There
date of
is
his
a
submission, one cannot.
provision
my
here,
lord.
na? Where is that GEM portal? They say so.
There will be guidelines from.
Yeah. Page 45, miss. Further, if any seller, any seller has any objection against these additional clauses or otherwise on any aspect of the bid, they can raise their representation against the same by using representative provided in the bid details field in seller dashboard after logging in as a seller within 4 days of the bid publication on the GEM. Buyer is duty bound to reply to all these representatives, not be allowed to open bid if he fails to reply to such representation. You have not taken this
Not
step
taken,
also.
Oh, this is like it's still there.
Huh?
Before bid opening.
Let us have it as an academic issue. Today I have been a bit kind enough. Otherwise, case of dismissal.
I leave it to your worship. My lord, your worship has noticed the, my lord, the fact, my lord, I leave it.
But you see, the question is, otherwise your reputation has become infructuous. You see, there were certain avenues open. First, the pre-bid, you did not. Maybe you must have lost your chance here. But you had a 4 days window. This window is very important. This is always there in all GEM, isn't it?
Yes, madam. This is a
This
standard format.
thing is very much there. Now you have approached this court so late. What to do? We should notice this.
Let him keep pending, my lord, let him also open instruction whether, my lord, they can accept physical copy. my lord.
No, that I am not going to ask that.
No, we cannot, I have.
Because that would be asking them something as if this court has no knowledge about the e-portal.
Portal itself is, my lord, clumsy, my lord.
That is not permissible as per the Procurement Act. In fact, that day, Mr. Gogoi, I was looking into the Procurement Act as well as the rules.
Well,
Very nicely made, very nicely. Each and every aspect have been duly taken note of. And I had delivered a judgment against the health department. It's a different thing. But a very interesting concept. I didn't know about this. Neither any argument was made, but while going through it, then I saw that there is a very interesting concept of a rate contract.
late contract.
Have you
yes.
seen the judgment?
My lord, regarding my lord, that debarment and all. my lord.
The Nestor Pharmaceuticals.
Yes.
Have a look at it. It's a very interesting point. Anyways, now every petitioner is taking time for filing additional pleadings. Anyways, so we issue just a notice, but no stay, nothing. No stay, nothing. Yeah, it will become infructuous, but on a larger issue. We issue a notice to that effect. We don't stay it, but keep the open so that tomorrow we have it early. Tomorrow you are challenging the term, na? Tomorrow, if we hold it that it is not permissible as per the Procurement Act and all, then the tender will go. I think that is a better option left. Issue notice making it returnable on. But the problem is again, in the meantime, you have to find out who are the bidders.
Yes, my lord.
Yes, yes.
You have to implead them also because they some rights will be constricted. Issue notice making it returnable on 28th of January 2026. Mr. B. Gogoi accepts notice on behalf of respondent number 1, 2, 3, 4, and 5. Extra copies of the writ petition be furnished to him tomorrow. By tomorrow.
Right.
The case of the petitioner herein is that the petitioner is an experienced
Medical feed supply.
is an experienced in providing dietary kitchen services throughout in various prominent health institutions in the country, such as All India Institute of Medical Science Patna, All India Institute of Medical Science Raipur.
I'm not supplying there. I'm just pointing out that in those my lord cases, they don't have this type of clauses.
Oh, you are not. Where is your experience?
My experience is my lord, besides.
You said paragraph
those,
14.
We have. That is for the parity.
Now, where is your area? What is your experience?
Yes, yes. Which are those states? Jharkhand and West Bengal.
Huh?
Jharkhand and West Bengal.
The case of the petitioner herein is that the petitioner
9 hospitals.
is a reputed caterer and supplier of cooked diet for indoor patients of health institutions, including government order supplies. And it has a pan-India presence. Fusto. On 4/12/2025, the Health and Family Welfare Department, Assam, had floated a tender and on 4/12/2025, a tender was floated in the GEM portal bearing bid number GEM/2025/B/6965282, inviting bidders, eligible bidders for ইয়াতে পেজ 39 এটা মস্ত লম্বা কিবা লেখা আছে হেল্থ কেয়াৰ কিচেন ডায়েটৰী সাৰ্ভিস ডেট জেনেৰেল সয়েন্সো এইবোৰ গোটেইখিনি The bid end date is 18/12/2025 at 11 a.m. Be it as it may, the petitioner is aggrieved by two conditions in the additional qualification sought for. That is, that the bidder must possess valid PAN, GST registration, that the bidder must possess GST registration and trade license registered in the state of Assam for the last 7 years. The learned senior counsel appearing on behalf of the petitioner submitted that the said clause is arbitrary, is not only arbitrary and unreasonable, but also lacks, debars reputed firms outside the state of Assam to participate in such bid process. The learned senior counsel submits that on account of lack of competition, it would only lead to monopoly, lead to lack of competition, it would only lead to higher price being fetched. Whereas better quality and lower price can be provided when the competition is more. Mr. B. Gogoi, the learned counsel, appearing on behalf of the respondents, however, submitted that the petitioner had the opportunity to raise all these aspects in the pre-bid meeting, which was on 6/12/2025, or even in the GEM portal, which is also wherein also an avenue have been provided. He further submitted that all the tenders issued by the Health and Family Welfare Department seeking dietary kitchen services are all similarly worded, isn't it?
Well,
Huh?
yes, madam.
Similarly worded and contain similar conditions. He further submitted that the question of acceptance of the petitioner's bid now does not arise, taking into account that the bid end period had already, and the bid period have already, the bid submission period has already come to an end at 11 a.m. on 18/12/2000 or today. And immediately upon the time so fixed in the bid document, the said the portal would also not accept any further bid. This could have heard the learned counsels appearing on behalf of the parties and is of the opinion that the question of passing any interim directions at this stage does not arise. Be it as it may, this court, however, observes that if it is found that the bid condition which have been assailed in the instant proceedings, that is clause 2C of the additional terms and conditions is found to be arbitrary and unreasonable, this court may consider setting aside the entire bid process. The respondents are directed to bring on record their stand by filing the affidavits on or before 21/1/2026. Liberty given to the petitioner to file reply thereagainst.
Clause 2C. Clause 2C, not 1C.
2C. 2C এ কৈছে 2C এ কৈছে হেৰি কি হ'ল এইটো সেইটো এটোৱে লাষ্ট মেটাৰ কোনটো কি মানে Okay, we'll have it some other day. Anything? What is that?
She had asked me to prepare needs of food.
You don't want to take further risks today after the debacle in the morning hours? No, not today. Yeah, end of the day. I've already so many judgments to sign.
End of the year also, Milord.
End of the year also. This year there has been sufficient progress in the High Court matters.
Has to be.
Huh?
Has to be. I think there is not much matters left. I don't think there is much matters left. Lordship has disposed of a majority chunk,
Oh, 16.
and that is good for the institution also. That is good for the High Court and that is good for the institution also, Milord.
No, in fact,
Because
if our
disposal is like,
if the staff of the High Court or for that matter, the ministerial staff of the subordinate courts have to wait for years for a decision. Now, in her case, with that directions, I think the petitioner, if an advertisement is given,
he
and
also
some
gets
parameters
that-
is being given, age relaxation, past experience, work experience,
Yes,
then on that basis, there's a strong likelihood that the petitioner would get it.
correct, Milord, correct.
And if
And-
this matter would have been done earlier, all this while the petitioner would have got that money, a better salary.
Yes,
Now, another aspect is the most serious aspect is if by this manner a post is kept blank and you don't fill it up,
it may get abolished. Never
the
know.
finance SIU department, you know them, na?
Exactly,
They will say
Because
that
first salary is
why
not
it is
released.
necessary, let us abolish that post.
exactly.
It's a very dangerous proposition. What has happened? So it requires, now you will get it. In fact, you could have got it a long time back.
Correct. And the appointing authority will also have this thing in its mind that this person is continuing for, it's, everyone is a human being after the end of the day, Milord.
So I was a little bit scared and I had a talk with him then. I was also happy with that regard that Madam in Asmith was saying, "Kiba ka hobo etia," he was telling me that.
That's the feeling of a litigant, Milord, with all due respect.
Because you see, he would have otherwise got it in the year 2018-19.
Exactly.
Now with this, and because that, when that observation was there more particularly, it was not we kept pending out there. Anyways,
That's the
yeah,
feeling.
I remember your matter. Anyways, we'll have it some other day.
Fine.
Yes, I will take up that matter. Khobor na? Khobor is done. Khobor is over.
This is where they agreed that.
Much obliged.
Huh?
Relax. This is where the other side agreed that I will get. This is.
Oh, this one, the other one, na?
Yes, management.
The
SCIT,
3 lakhs.
The joint affidavit has been filed.
File, na?
It's on record.
So we close it.
Yes.
Your
stayed and
matter,
came within a
madam,
month.
will have it after vacation? Well, after Bihu? No, you are enjoying an interim order?
Very fair, my lord. Actually, he's worried about this result will affect a lot because he's really worried about this big matter.
No, already there is a direction that whatever is decided.
No, my lord, he is a common litigant, so he is not much aware of everything. We cannot expect him to understand me, but he is very cautious about this matter. Even at 10:30 when my lordship sees he used to call me, Sir Bohile. My lordship, I have been in big trouble since many Thursdays. So he is, I know his life now also. My lordship, it may be fixed.
Mr. Das, I think we need to finish up this matter because she has already one day put a blame upon me. That day. I still remember whenever I see her face, I remember that aspect that she had to miss her daughter's birthday because of me.
No, no, no.
I know
that.
Anyway, we'll finish it.
As per her
It has to be
convenience.
finished.
As per her convenience.
Okay, we'll finish it up then. Let us have it on 22nd of January.
Fine.
22nd it will be difficult, 29th of January.
should we decide?
Also, due to paucity of time, the matter could not be, the hearing of the matter could not be completed. Considering the above, list the matter on 29/1/2026. Name order partially shall continue. Please.
Joint affidavit, paragraph 6, they says there'll be account transfer in the details given
You've given
within
it?
1 month of the exposure.
Hello?
The paragraph 6 at page 167, that's all.
This is my third matter this month pertaining to doing this thing, I mean, setting aside all these things, the award and all these things, bringing us closer to the industrial dispute. Where's that affidavit?
That's on record.
Join.
Page
Therefore,
167,
heard,
paragraph
Mr.
6.
W Rahman on behalf of Mr. K. Kalita.
What?
W Rahman on behalf of Mr. K. Kalita.
Where is K. Kulita?
He had a doctor's appointment with the lot, we could not make it.
They cannot be on behalf of the
He is
WA.
capable of-
Mr. So-and-so appears on behalf of the petitioner. And Mr. So-and-so appears on behalf of the respondent. You have signed the wakalatnama?
No, no.
Okay, এটা কে কইলতাক দিয়ে দিব? The instant petition has been filed. Instant writ petition has been filed challenging the award dated 3rd of March 2015. 15, na?
Yes.
Passed in reference case number 09/2001 by the learned Labour Court of Assam at Dibrugarh. When the instant writ petition was taken up on 22/7/2025, and on 11/12/2025, this court inquired as to whether the matter can be amicably resolved. Taking into account that the proceedings have been pending since 2001. And the petitioner no longer has any office in the state of Assam. Accordingly, this matter was fixed on 12/12/2025. On the same date, the learned counsels appearing on behalf of both the parties apprised this court that an amicable resolution of the dispute had been arrived at, and as such would like to file a joint affidavit in the instant proceedings. In terms with the said submission, a joint affidavit was filed on behalf of the petitioner as well as the respondent, sole respondent, or
Number 1.
respondent number 1. The amicable settlement so arrived at by and between the petitioner and the respondent number one is recorded in paragraph number 5, 6, and 7, 7 and 8 of the joint affidavit, which is reproduced herein under. First, taking into account, this court have also heard the learned counsels appearing on behalf of the parties and is satisfied that the said amicable resolution is without any force, fraud, or undue influence. First, considering the above, this court therefore disposes of the instant proceedings in terms with the said amicable resolution, the amicable settlement, with the following observations and directions. The petitioner company is directed to disburse a sum of rupees 3 lakhs to the respondent, the details of which is provided in paragraph number 6 of the joint affidavit. The same be done on or before 31/2026. Full stop. Number 3. Upon disbursing the said amount, the respondent petitioner is further directed to file an affidavit of compliance before this court on or before 6th of February 2026. Next. It is further observed and directed that upon disbursing the said amount to the respondent number one in his bank account and the details and the bank account, comma, the same would constitute a full and final settlement of the claim of the respondent number one. And the respondent number one shall have no, respondent number one, full stop. Now last, it is observed that if the affidavit of compliance is not filed on or before 6th of February 2026, the matter be again listed before this court by the registry.
In the event file, I mean, then the matter should be closed.
No, it's closed.
It's closed.
Then otherwise what will happen? If they don't pay tomorrow, just for example, they are paying. This is a compromise. So tomorrow, if they don't pay, then what do? You have to file an IA, isn't it? That they have not complied. So it is not required. So therefore, I'm asking them to file an affidavit in compliance. If the affidavit in compliance is not filed, the matter will be again listed. Then I'll get hold of him. At last finished.